Good morning, everybody. Happy Wednesday. Welcome to the Courtroom Files Live. We'll start our day with Judge Simpson. He's running a criminal docket and a much more aggressive game of Hollywood Squares than they're normally playing there. So let's see what's going on.
As I said, hi to Anne.
Thank you, Your Honor.
Right. Thank you. That's true, Your Honor. And the agreement is it's extended HIDA, so it's necessary for.
The prosecutor.
Yes, thank you.
All right, very good. May I have her?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? So, state your name.
Jillian Sartori.
You can.
All right. I'll just need you to speak up a little bit if you would, okay? Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of retail fraud in the third degree. That is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased at 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes.
All
Your
right.
Honor.
Your Honor.
And understanding all of that, do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty, Your Honor.
You understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any questions regarding any of those rights?
No, Your Honor.
Look at paragraph 5 on that form. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily,
Yes, Your Honor.
of your own free will,
Yes, Your Honor.
and also because you believe that you are indeed guilty of this offense?
Yes, Your Honor.
On the date, hang on 1 second, should have gotten this earlier. Let me put my complaint. Seriously. Hold on. Do you see the complaint in this one? I don't. No.
I think that's the second page right there.
You open a file without a complaint.
No, I got it.
Court need a copy?
You're right. Thank you.
You're welcome.
First, I get it. On the date of October 18, 2024, at the location of 3749 Carpenter Road in Pittsfield Township, Washington County, State of Michigan, what did you do at the Target store that makes you think that you're guilty?
Could you repeat the last sentence?
What did you do at the Target store that makes you think that you're guilty?
I stole from Target.
Okay, you went into the store
Yes.
and you took some items.
Yes, Your Honor.
All right. Tried to walk out of the store without paying for them.
Yes, Your Honor.
The store was open to the public at the time.
Yes, Your Honor.
You didn't have anybody's permission to take that property, did you?
No, Your Honor.
And the property you took was property that was offered for sale by Target?
Yes, Your Honor.
All right. Ma'am, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, you commit misconduct as defined under the Michigan court rules, the court would no longer be bound by any sentence evaluation or agreement. You understand that?
Yes, Your Honor.
You also would not be entitled to withdraw your plea. You understand that?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor, the people are aware of an additional case that would technically be a bond violation for this case. We're not intending on pursuing it as a bond violation case. Want to make sure the record's clear on that.
All right. And
Thank you, Your
the
Honor.
court had been apprised of that.
Yes.
Thank you.
All right. Any other things?
No, Your Honor. Thank you.
And has the court complied with the court ruling? Would it be proper to accept this defendant?
People are satisfied?
Yes, Your Honor.
Court will accept the defendant's plea of guilty to this charge. Defendant is referred to probation for a pre-sentence investigation and report. Sentencing in this matter will be September 24th, 2025. Are we doing that?
Pardon, Your Honor?
Yes.
9 a.m. Bond with its conditions will continue.
Thank you, Your Honor.
Thank you, Your Honor. Conference room.
Court does call the case of the people versus Aline Wood.
Ashley Feltus for the people.
Morning, Tom Pietrowski on behalf of Ms. Wood, who is in court today. Standing to my right, ma'am, would you introduce yourself, please?
Hello, my name is Aileen Jane Wood.
Thank you. All right, what are we doing?
Yeah, I believe we're at a point where we're just asking the court to set a final settlement conference, and I think those dates are sometime in October.
Jury final settlement conference, we set October 17th, 2025, 9 a.m. Jury selection, if necessary, October 20th, 2025, 8:30. Both of those proceedings are in person.
Yeah,
Thank you, Your Honor.
may I ask the court a question?
Yeah, I don't know if I'll, go ahead.
For scheduling purposes, we would be intending, and I let Ms. Lonnie, I'm sorry, let the prosecutor know that I haven't changed my name, believe it or not. That our intention would be to waive. I don't know if the court needs to know that now or.
You want to proceed to this and then make a determination that you may waive.
That's correct, Your
All
Honor.
right.
We
Yeah.
would bench after counsel.
Right,
All right, very good.
sounds good. Thank you, sir.
Thank you. Bond will continue. Court does call the case of the people versus Joseph German.
Your Honor.
Ashley Feltus for the people.
Good morning, Your Honor. May it please this honorable court. My name is Jay Dallow, P number 72879. Appearing on behalf and with my client, Mr. Joseph German, who stands to my right. Sir, can you please state your name for the record?
Joseph German.
Your Honor, today's date and time set for a pretrial on this matter. I've had the opportunity and the pleasure to speak with Sister Counsel. Ms. Feltus to my
That's
left.
funny. Pleasure. Go ahead.
But it's true.
Yeah, okay, whatever. You're still young. Go ahead.
Thank you, Your Honor. We're going to be submitting, we've submitted a deviation request. We've updated and had it forwarded to Sister Counsel. I think both parties are just asking for 2 weeks if we can return. If Zoom, if it would please the court to appear via Zoom. As much as I love Ann Arbor and I went to school here, I did
Sorry
drive.
to hear that.
Oh, okay. You're not a Buckeye, are you? Okay.
Alan, take it.
Well, you are wearing red.
Am I a Buckeye?
Oh, I did.
To Michigan. I grew up here, but he went to Michigan and he asked me if I'm a Buckeye.
Yeah, well, based on
You
your,
want to know? You want to know?
I did drive about. I live in Sterling.
He's just not acquitting himself well.
Um,
So
I-
any request you make, no.
Good. So any request?
I am a
No.
very proud Maryland terrapin.
Oh, that's cool.
I know.
So any request I say ask would be no. So we would like to appear in person. So
No.
yeah.
Okay.
Perfect.
Very good.
You're right. Yeah. Thank you, Judge.
What's my next date? 17. Does that work for you?
That's perfect, Your Honor. Thank you.
I'll adjourn the matter to September 17th, 2025, 9 a.m. Bond will continue, and you'll have to submit the form and then consider the Zoom request.
Oh, yes, Your Honor.
All right?
Yes. Thank you. Have a great day.
You do the same. Court does call the case of the people versus Eric. Is it Kenise or Hank?
Casey.
Casey.
Ashley Feltus for the people.
Good morning, I'm Robert J. Killen. Mr. Casey?
Your name, sir?
Eric James Casey.
All right, thank you.
Your Honor, Mr. Killenwall presented some information to me yesterday. I need to discuss with Detective Yeager about this case, so I request an adjournment for that purpose.
Will 17th work?
That's fine, Your Honor. Thank you so much.
This is September 17th, that's a Wednesday.
Good. Yeah.
Okay.
Adjourn the matter September 17th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you. Court does call the case of the people versus Jason Eckley.
Ashley Feltus for the people.
Good morning, Your Honor.
Good morning. Go ahead, counsel. Place your appearance on the record.
Thank you. Good morning again, Your Honor. Robert Goldman, P81222, appearing on behalf of defendant Jason Eckel, present by way of Zoom this morning. We thank the court for its accommodations to appear by way of Zoom. Mr. Eckel, could you please state your full name for the record?
Jason Eckel.
And what are we doing today?
Thank you, Your Honor. This is a date and time set for a first pretrial in this matter. I did receive discovery from the prosecutor's office. I do need to follow up regarding one piece of discovery that I'd like to further inquire into. However, in the interest of judicial efficiency and economy, I would ask if the court could schedule the matter for a final settlement conference during which, in the interim period, I can address the request or inquiry with the prosecutor's office. And otherwise prepare to try to resolve, but if not, we'll be prepared to proceed with trial in the matter.
Your Honor, if the court wouldn't mind, could we just adjourn the pretrial rather than setting it before we have all the discovery over? I want to make sure defense counsel has everything he needs. We don't have to delay this case at final settlement if there should be something missed.
Well, if you're looking for additional information and discussion, I'll just adjourn the pretrial out. I'll adjourn the pretrial to September 17th, 2025, 9 a.m.
And Your Honor, I'm getting into the Zoom in just a moment. I'll put my contact information in the chat so defense counsel can email me directly.
All right, very good.
Thank you.
And I'll be right there.
All right, thank you. Bond will continue with its conditions. Thank you.
Thank you, Your Honor.
Court does call the case of the people versus William Dapkowski.
Good morning, Your Honor. Paul Pavelski for Mr. Dapkowski, who is in person.
Yes. Your name, sir?
William Dapkowski.
All right, very good. What are we doing?
Your Honor, Mr. Dapkowski, the last pretrial was adjourned for Mr. Dapkowski to be screened for participation in the sobriety court program, and I did receive an email from Mr. Heaton that he had been approved and accepted for participation in the program. So we would be prepared today to tender a plea to the charge of OWI second. And Mr. Heaton asked for a sentencing date of 9/25 at 9:30 a.m. for him to be accepted into the program if court will go along with that.
Well, I have to, how are we doing that? Are they sentencing the entire sentence or the transfer of that into 14A? Do we have clarification on that?
We do not have clarification. I do know that we received an email from Mr. Heaton that indicated that they could see him the day after our next sentencing docket.
So I would set we're just going to do it that way.
Yeah.
All right. So what will happen, counsel, is I'll be here. He's got the 25th date, but I will be setting my sentencing date because it's a little bit weird, but I will be assessing at that time fines and costs and then referring him to the court. Seems an odd way to do it since we're all one court, but we haven't worked out all of the details. All right.
Thank you, Judge. That's fine.
All right. Very good. Sir, if you could please raise your right hand to be sworn.
You solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, self.
Yes.
State your name.
William Dapkowski.
And he's going to plead to operating while intoxicated second offense. Is that correct?
Yes.
All right. Sir, it is this court's understanding that you're going to plead guilty to the charge of operating while intoxicated second offense. That is a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court costs. The court could order community service and any rehabilitative services the court deems necessary. The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand all of that, sir?
Yes, Your Honor.
And understanding all of that, you still wish to plead guilty?
Yes, Your Honor.
I do also have to advise you that, well, actually you'll be sentenced by me, but you'll also be appearing before Judge Freshour. You understand that, sir?
Yes, Your Honor.
All right. Still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now you understand that by pleading guilty, you'll not have a trial of any kind?
Yes, Your Honor.
All right. Did you sign an advice of rights form, sir?
Not at this time, but I can do that.
Okay.
He may have done one. He may have done one previously, Your Honor. I'm not sure, but I did review the form with him.
Do you recall reviewing an advice of rights form with your attorney?
Yes, Your Honor.
All right. Do you have any questions? I've handed you a copy. Do you have any questions regarding any of those rights?
Not at this time.
All right. Please look at paragraph 5. You'll see a copy on the podium highlighting paragraph 5. Those are your rights which are part of the trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been, well, has anybody promised you anything to get you to plead to this charge?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
of your own free will,
Yes, Your Honor.
and because you believe that you are indeed guilty of this offense?
That is correct, Your Honor.
March 12, 2025, at the location of Laura Road near Textile Road, Pittsfield Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, Your Honor.
Prior to operating that motor vehicle, did you consume intoxicating liquor?
Yes, I did.
What did you have and how much?
At least a pint and many beers. So I was
Pint of,
vodka.
okay. Were you stopped by the police or was there an accident?
I was stopped by the police for speeding.
For speeding?
Yes.
All right. You're not disputing the right of the police to stop you, are you?
No, Your Honor.
All right. Were you ultimately arrested?
Yes, Your Honor.
Were you taken to the hospital or to the station?
I was taken to the police station.
All right.
And Your Honor, I have the results of the.
Was that an intoxicator?
It was intoxilizer, yes, Your Honor.
Okay. And were the results of that 0.137, sir?
Yes, Your Honor.
All right. Do you have any reason to dispute those results?
No, Your Honor.
All right. Prior to that, on July 14th, 2022, City of Adrian, were you convicted of operating while visibly impaired?
Yes, Your Honor.
All right. Sir, I do have to advise you that if you commit misconduct as defined in the Michigan court rule between the time of my acceptance of your plea and the time of sentencing, that any agreement or evaluation, the court would no longer be bound by. You understand that?
Yes, Your Honor.
All right. Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
Your
No,
Honor,
Your
only the entry into sobriety court that we've already.
The entry into, right.
Nothing else.
Nothing else, counsel?
No, Your Honor.
All right. And have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied.
Defense is satisfied.
All right. Court will accept the defendant's plea of guilty to this charge. Has he already been assessed at, he's done an assessment already, is that correct?
Yes, he has with probation, and Mr. Heaton has sent an email accepting him into the program.
Okay, so here's what I'm gonna do. I'll refer you, I'm not gonna refer you to Von Swartz, but I'll refer you for an assessment, which you've already ideally completed. I'll set sentencing for this part of the case for September 24th, 2000, is that right?
Yes.
September 24th, 2025, 9 a.m., or as your invite indicates. And then you'll have the next appearance on the 25th.
Okay.
Okay, we'll do it that way. Bond with its conditions will continue. Thank you.
Thank you.
Good morning once again, everybody. Welcome to the Courtroom Files Live. It is Wednesday, which, I suppose technically is still the new Friday because I don't think we changed it permanently. We just changed it for last week. So we'll say it's the new Friday. Let's go say good morning to Judge McNally. We'll keep an eye on Judge Simpson because he's in a good mood. But some lady is dragging a small child up to the podium with her. So let's see which one's in trouble, the lady or the child.
Do you work?
What was it?
Do you work?
Yes.
Where do you work? Are you married?
No.
Is the father in the child's life?
No.
You've had this outstanding now for over a year.
So I went to court and paid all my tickets in like February, and somehow, I seen you, but somehow this one got like missed.
Do you have this to pay?
Yeah.
Okay. I'll tell you what, I'll cut it down. You owe $248. You collecting child support?
No.
Why not?
His dad's on SSI and I can't get him.
It's gotta be tough. Do you have just one child or more? And you're supporting 3 children? Is it the same father? How old are you?
25, about to be 26.
Is he in the and he's not in the child's life? None of them? Well, that's great. These guys bring children into the world and they don't care about them, huh? Amazing. I'm gonna cut it down to 180 for you. I'll waive the balance. You go down and pay 180 and we're all set. Good luck. I feel for you. Hang in there one day at a time, okay? Good luck there, young man. How old are you? What's your name? What's your name? What is it?
Charles.
Charles. How's it going, Charles? Charles, how old are you?
3.
3. Cool. All right, be good for your mom, okay? What is this world going to be like when that child's my age, Lisa? That's what I want to know.
That is a great question from Judge. What will the world be like indeed? Looks like he's in between stuff now. Let's go say good morning to Judge Glazer, see what kind of a start she's off to.
Okay.
She's off to a silent start. We'll come back to her. Let's stay in Florida, but we'll check out Wade Mercer.
Mr. Torres, good morning. Your wife and your parents are in the courtroom, sir. You're here because you've been accused of 1 count of burglary of an occupied dwelling and 2 counts of misdemeanor assault. Mr. Torres, I've read the complaint. There is probable cause in the complaint, and I've also looked at your criminal history. Mr. Torres, I see several prior charges, although nothing near as serious as this that I see. Mr. Torres, I think you're entitled to a bond, but I'm going to see what the attorneys have before I set that bond. Mr. McDaniel, anything on behalf of Mr. Torres?
No, Your Honor.
Mr. Mitchell?
No, Your Honor.
Mr. Torres, I'm going to set your bond at $25,000 on the burglary of a dwelling. That's a 2nd-degree felony, and it's going to be $5,000 each on the other 2 charges because those are misdemeanor charges. Your total bond, Mr. Torres, is $35,000 cash or surety. You have a condition to have no contact with the alleged victims and no contact with that property. So, Mr. Torres, if you, from this point forward, you can not have no contact with either of those individuals and you can have no contact with that property at all. You will get to use the phone in just a few minutes to try to post the bond, and if you do, you'll be released. I'm going to ask the jail to give you a notice for your for the next felony arraignment date, which will be
7th, I think.
October the 7th at 8:30 a.m. They'll give you that notice, Mr. Torres, at the jail. Let me see if your family
Yes,
has
sir.
any questions first. Y'all have any questions? So with that bond, he can go through a bondsman, or he could put up the whole money if he has the ability to, and he can be released. He just got to stay away from that residence and those people if he's out. Even if he's not out, he's got to have to stay away from them. Okay. Mr. Torres, do you have any questions?
No, Your Honor.
All right, sir. Wish you the best. Thank y'all for coming. Trevette Smith. Yeah, we're first. Thank you. Sure. Mr. Smith, good morning. Mr. Smith, you've got 3 different charges. You're accused of 1 count of failure to appear for an arraignment in 25-191 CF. That's an older case I think you were on bond on, and then allegedly you missed a court date. There's no bond on that warrant. Then you have 2 new charges. You're charged with 1 count of petty theft, 3rd or subsequent, which is a felony charge, and 1 count of burglary of an unoccupied structure. So on the burglary of there's probable cause on the petty theft. On the burglary of the unoccupied structure, Mr. Mitchell and Mr. McDaniel, it appears to be a dwelling, and in the body of the complaint, the officer says dwelling, but then when he gets to the statute point, he uses structure instead, the structure statute, which is lower degree crime. Mr. Mitchell, that's what it looks like to me anyway. Mr. Mitchell, any input?
No, Your Honor, we can just place bond as if it's a third degree felony.
Mr. McDaniel, anything on that issue?
Nothing on that issue, Your Honor.
So I'm going to find probable cause for burglary of a structure because that's what the officer charged him with. I'm going to ask you to notify the officer. He clearly says dwelling in the body and clearly uses the structure, he or she clearly uses the structure statute numbers. I think it's just an oversight. But there's probable cause for burglary of a dwelling. He just didn't charge you with that. Mr. Smith, I'm going to set you a bond. Even though you've got no bond in the other case, I still think you're entitled to one on the new charges. I'm going to set your bond at $25,000 on the burglary of the structure case. The reason it's that bond is because, as I said, there is probable cause for a higher charge and you're already out on bond. And the bond on the petty theft felony will be $5,000. So, Mr. Smith, one case you've got no bond on. The other charges you have a $30,000 bond on with a condition of no contact with the alleged victim and no contact with the property. So, Mr. Smith, you will get a notice for, I'm going to ask the jail to give you a notice for the October 7th docket at 8:30 in the new cases. Actually, it'd be October 7th at 8:30 in all cases because the court date you supposedly missed was an arraignment docket. So October 7th will be your court date. They'll give you that written notice at the jail, but then they'll take you to the court date because you'll be in custody unless Judge Garcia changes something between now and then. Mr. Smith, do you have any questions?
Yes, sir. Well, we might can get that failure to appear straightened out because of the.
Yeah.
Judge,
I'm going to interrupt this for a minute and go back to Judge Glazer. Her audio is working, but this lady in front of her apparently is accused of shooting somebody at a birthday party.
After she was aware that this shooting occurred.
Your Honor, the date of the alleged shooting is August 20th. They're saying that the ride sharing was yesterday, September 2nd, so that's almost 2 weeks after.
It's an ongoing offense. She's aiding the murderer.
And it doesn't say that any of these firearms match anything to murder, Your Honor, or the shooting.
I think there's enough for probable cause based on the totality of the facts alleged in this arrest affidavit. I'm going to state it's a
She's
first
not
degree.
charged as a principal. She's charged as accessory after the fact. It's a first degree felony.
What bond do you want? $15,000?
Yes.
$15,000 bond. Good day, ma'am.
Thank you, ma'am.
Okay, we'll go back to Judge Mercer. I just wanted to catch that real quick because the facts around it were quite interesting. It sounds like they're charging her as an accessory actually, but from what I gathered, it was a shooting at a birthday party, and I think it was a birthday party for a minor. So messy. Anyways, let's go finish up with Judge Mercer.
Yes, sir.
Do you want me to let him know that you were here, ma'am? Trevette, Mr. Smith. Mr. McDaniel, get him, please. Your relationships, I can tell him.
yes, sir.
She just came in right at the end. I just wanted you to know she was here.
Yes, sir.
If I was there and my mom showed up, I'd want to know that. Your mom did come in, okay?
Yes, sir. Thank you, sir, Mr. Mercer.
Yes, sir. Good luck to you. Thank you for coming, man.
All right, yes, sir.
Nathan Hicks.
Yes, sir.
Mr. Hicks, good morning. Mr. Hicks, you're here because you've been accused of three misdemeanor charges, two felonies and one misdemeanor charge. You've been accused of one count of battery on law enforcement officer, second felony of resisting an officer with violence, and a third charge that's a misdemeanor giving false name to law enforcement officer. Mr. Hicks, there is probable cause for those charges. The complaint implies there may be an additional charge coming of grand theft. It also implies that you are allegedly an escaped juvenile from a facility in Alabama. So for those reasons, you're certainly not going to get a conditional release, but you're entitled to a bond as far as I can tell. I think the state has moved your case up to adult court from the juvenile system because you're getting close to being 18. Mr. McDaniel, any additional information that you want me to be aware of before I set a bond in this case?
No, Your Honor.
Mr. Mitchell.
I think you covered what I was going to say, so nothing else.
Mr. Hicks, I'm going to set your bond at $10,000 on the felonies. That's $10,000 each. $5,000 on the misdemeanor. Your total bond, Mr. Hicks, is $25,000. Keep in mind that if they do charge you with additional grand theft, that would change the bond. Also, keep in mind, before you or your family try to post the bond, I have no idea what's going to happen with Alabama. If Alabama is going to put a hold or a detainer on you, I have no idea. But that's something you need to keep in mind before you or your family try to post a bond. Mr. Mitchell?
I will address that right quick. I've been in contact with DJJ. They've been in contact with Alabama. When they were talking about possible extradition back to Alabama, they were just planning on having him go back to the program that he was in up there and still stay in the juvenile system. So I think what we've agreed is for the time being, he's going to stay here and they're not going to put a hold on him for Alabama.
So what if he posts bond here?
If he posts bond, there's not going to be a hold. I don't think so.
So if you do post bond, you would probably just contact your juvenile probation officer that you had in the state of Alabama or the juvenile authorities there. But you have the right to post bond. Whether you do or not is up to you. Yeah, that's it. Any questions, Mr. Hicks?
No, sir.
I wish you the best, sir.
Thank you.
Yes, sir. Ernest Wombles. I think on Mr. Wombles, the best I can tell, the jail sheet is wrong. The jail sheet says 2 counts of burglary, and that doesn't match the it doesn't match the actual complaints filed by law enforcement. It looks like he's actually been accused of, let me get to that page. He's been accused of 2 counts with burglary with battery or burglary with some form of battery or assault. And I did have some probable cause questions on that this morning. So I sent an email or a text to the attorneys. Mr. McDaniel, you want to be heard on probable cause on the 2 charges, sir?
Well, just, Your Honor, that you can't be charged with 1 count of burglary, and I'm not sure how the state's going to end up charging this. I want to say I agree with, I thought I recall seeing at the first page that they just charge you with burglary, but clearly in the complaint that they charge you with, and it play all the facts, some kind of, a battery that happened, aggravated battery probably. But so that's all we have is just ask the court to consider this just being 1 burglary charge. But
Mr. Mitchell.
So, Your Honor, we do suggest that there is probable cause for a burglary with battery. And I just wanted to let you know that I made contact with the victim earlier this morning, and I just wanted to put out what she told me regarding this for first appearance purposes. She told me that this defendant lives about a mile away from her. She doesn't think that any type of bond, unless it's like really high, is going to keep him away from her. She says that he tried to slit her throat during this, has harassed her for months, has been constantly texting her, says that he is obsessed with her, believes that he has mental and drug issues. And she believes that if her friend wasn't there, because she was alone at first because her fiance was in the hospital for something, she believes that if her friend wasn't there, he may have killed her. So, and she even said that at one point during this, he took the phones from both her and her friend when he set them down on the bed and threatened to kill her. So, or to kill them both. So she just wanted me to let you know this, and I told her I would pass this on to you, and we would request a high bond, given the fact that this does appear to be a burglary with battery. We would also request that he have no contact with her of any kind, and we need to emphasize with him, no texting, no even waving or nodding, any type whatsoever, and of course, stay away from her property.
Okay, thank you. You agree that the law enforcement cannot charge him with 2 burglaries for 1 entry?
I agree with that, yes.
And considering that's a first degree felony and everything you put on the record, is the state going to be filing a motion for pretrial detention or not?
At this time, I don't think so, no.
All right, so if the state files a motion for pretrial detention, or if they tell me they're going to, Mr. Wombles, then I would probably just hold you with no bond, at least until you see Judge Garcia. They're not doing that, so that means you're entitled to a bond. The next question is, how many bonds do I set you? And the law is very clear based upon the case law I found this morning and I provided to the attorneys. You cannot be charged with 2 burglaries for 1 entry, even if there are multiple people in the home. Burglary is the act of entering the home. It's not dependent upon how many people are there. So you can be charged with a burglary, and then there may be other charges like assault or battery or whatever that happen inside the home, but there's only 1 burglary. And the officer did correctly put the correct burglary with a battery statute number, even though he just said burglary, the statute number right next to it is a burglary with a battery. And there's a big difference between burglary with a battery and burglary. One is a first-degree felony punishable by life, and the other is a second-degree felony punishable by up to 15 years in prison. So there's probable cause for one count of burglary with a battery. There's not probable cause for the second charge. The burglary with a battery is going to get you a bond of $50,000 cash or surety with a condition of no contact with the alleged victim at all, alleged victims at all, no contact with any of the occupants of the home at all. Mr. Wombles, you've got the right to use the phone to try to post a bond, sir. If you post a bond, you'll be released. I'm going to ask the jail to give you a notice for your next court date. That will be October 7th at 8:30 will be your next court date. Mr. Mitchell, any other special conditions you're requesting?
Did you say also no contact with their property?
And no contact with that residence at all. Thank you, Mr. Mitchell.
Okay. Other than that, I think that's it.
So, Mr. Wombles, you will get to use the phone in just a few minutes, sir, to try to post the bond, but from this point forward, you can have no contact with those individuals until this thing gets sorted out. Do you have any questions, sir?
Yeah, but you might not want to hear it.
I'll listen to your questions if you have one. I may not be able to answer it, but I'll try.
That's all I wanted to say?
Yeah, nothing else, Your Honor. We appreciate it.
That's all I wanted to say.
All right. Wish you the best, sir. All right, Mr. McDaniel, it's everything I had on my first appearance list. Anything else from the public defender's office?
No, Your Honor.
All right, since he's wrapping up, we're going to go back to Judge Simpson, but I have it paused at the moment because there's two unique things. Number one, the guy at the bottom there, apparently appearing from space, from the side, and young Ronald Reagan is back, if you look in the bottom right corner. So let's roll with that.
We're fighting that in circuit court right now.
Yeah, but she did know at the time that she didn't have a 625G permit. Did she not? Counsel?
That I don't know.
Part of the problem that I have here, counsel, is that she's driving. She's not supposed to be driving. And then there is Fireball whiskey in the back of her vehicle. And she's not to be in possession or consumption of any alcohol.
I do understand that, Your Honor, and to my knowledge, she has been sober since the offense, doing everything she can. So I don't believe she had any knowledge of that fireball being present. As we have gone over her bond conditions with her, and she is very aware.
25. Okay, well, counsel, if you want to get down here so we can address this later, but at this time, I'm going to take her into custody. Your bond on the warrant that I issued is set at $25,000 cash surety. So she can post, or you can come down and I can have her brought back out. But at this time, I'm going to take her in.
Can she post a cash bond today?
Pardon?
Can she post a cash bond?
If she has it, certainly she could post a cash bond.
Okay.
I'll allow a 10% on it, so that she doesn't have to go through a surety if that would assist on that. But it's that would be $25,000. I'll give a 10% privilege on that.
Okay.
All right. What were we going to do with the case itself?
The case itself, like I said, we received discovery. I think we have some ongoing negotiations regarding an offer, and she does have a substance abuse evaluation scheduled, I believe, September 10th.
So what I will do is I'll adjourn her case to September 17th, 2025, 9 a.m. At this time, the defendant is remanded. Her bond will be set at $25,000, 10%.
Will the court also order the scram?
Not at this time.
Okay, thank you.
Thank you. Court does call the case of the people versus Justin Kitari.
People.
Good morning, Your Honor. Oscar Rodriguez, on behalf of Mr. Katarai, who is present, and speak your name, please.
Justin Katari.
All right. What are we doing?
Your Honor, I have not been able to with the prosecutor, but I do have a request to change the bond conditions that we'd like to make.
Okay, well, first of all, what are we doing on the case itself?
Your Honor, I haven't heard any offers. Again, prosecutor and I have not been able to chat, but that's where we stand there. Obviously, if we have no resolution, this case needs to move forward towards trial. But I'm not sure if there are going to be any offers.
Did you want an adjournment of the pretrial? You want me to set it on the final settlement conference?
I think we can get an offer here, Your Honor.
All right. I'll adjourn this out so you guys can talk. I'll adjourn this to September 17th, 2025, 9 a.m. Yes, as to bond.
Your Honor, we have been on the scram tether for now about a month and a half, and our request is to, in terms of saving money, to be put on the breathalyzer instead. The testing will still continue all the time. He has had no violations. He has his 30-day chip from AA, and so that's essentially the request. If we can go to the daily monitoring breathalyzer instead.
I'm going to deny that request. I don't need a response from the people. The basis for which he's on the scram tether is that his alleged blood alcohol was a 0.234. He has a prior driving while alcohol related offense, and there was a crash in this case. So I'm not changing that bond condition.
Thank you, Your Honor.
So request to change that bond condition is denied.
Thank you.
We'll see you in a couple of weeks then. Thank you.
Thank you.
Court does call the case of the people versus Eric Hopkins.
Ashley Feltus for the people.
Arraignment. Just an arraignment.
Good morning, Your Honor. Wonderful to see you. Robert Ellman with and on behalf of Mr. Hopkins. Mr. Hopkins, can you state your name for the record?
Eric Hopkins.
Thank you.
I don't have anything marked in this one. It is an arraignment. All right. As to the arraignment portion.
Your Honor, we would stand mute and waive formal reading.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea to this charge. All right. And what are we going to do in this case?
Your Honor, I've been having wonderful, fruitful conversations with Mrs. Feltus, and I'm hoping that we will soon be able to reach a resolution, but we need a little more time to figure that out. And so I would ask for an adjournment to your next pretrial date.
We'll adjourn the pretrial in this matter to September 17th, 2025, 9 a.m. or as your invite indicate, I'll set the defendant's bond in this case as a $5,000 personal recognizance bond. I'll order standard conditions, including no assault behavior or possession of any weapons. There is to be no alcohol, no use or possession of any alcohol, recreational marijuana, or any illegal drugs. You understand that, sir?
Yes, Your Honor.
I'm also going to order that you are not to enter any Home Depot in the state of Michigan. You understand that?
Yes, Your Honor.
All right. Anything further?
No, Your Honor.
Thank you. Court calls the cases of the people versus Rick Artuso.
Ashley Feltus for the people.
Assistant Public
One of them, not all of them.
Assistant Public Defender Natalie Pate with and on behalf of Rick Artuso, and the case is ending 1656 and 1657.
And good morning, Your Honor. May it please the Honorable Court, David Burgess on behalf of Rick Artuso as the remaining man.
Your name, sir?
Rick Artuso.
Okay, what are we doing?
Your Honor, there is a resolution as to my two cases. There should be a plea form in the file as well as a signed advice of rights form.
I see. Okay, I get it. Okay. And then what about your case?
Your Honor, Ms. Feltus has got that right today. I'm working on it, Your Honor.
Yeah,
I'm a little
me
slow.
too.
I'm a little slow sometimes, Your Honor. But she extended an offer to me. I do need to discuss with Mr. Artuso. So on my matter, I'm going to ask for an adjournment, Your Honor.
That's on 217.
Correct.
I'll adjourn that matter to September 17th, 2025, 9 a.m. is bond in that case. Will continue.
Thank you very much, Your Honor.
All right. And on the other matters, Mr. Artuso,
Yes.
can you raise your right hand, sir? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
Yes.
All right. State your name again for the record.
Rick Artuso.
All right. It's this court's understanding, sir, that you are going to be pleading guilty to the charge of no insurance.
Yes.
Is that correct?
Yes.
That is a misdemeanor punishable by a fine between not less than $200, not more than $500 plus cost. Do you understand that, sir?
Yes.
I don't think, and I think it's up to 1 year. Is that the one?
Correct, Your Honor.
And up to 1 year incarceration. You understand that, sir?
Yes.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form. Is that correct, sir?
Yes.
Any question regarding any of those rights?
No.
Looking at paragraph 5, those are your rights which are part of a trial. You understand that you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal upright.
Yes.
Are you on probation or parole?
Not at the moment.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense, sir?
Yes.
On the date of December 19, 2024, at the location of Hillside Road near Ellsworth, Pittsfield Township, Washington County, State of Michigan, were you operating a motor vehicle?
Yes.
And at the time you were operating that motor vehicle, did you not have insurance or security regarding that vehicle?
No, I did not.
Okay, and you knew that to be the case, sir?
Yeah.
Okay. Sir, if I accept your plea in this matter, between the time of sentencing, the acceptance of the plea and the time of sentencing, if you commit misconduct as defined in the Michigan court rules, you could not withdraw your plea, and any evaluation by the court or recommendation by the court would no longer be bound by. You understand that, sir?
Yes.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
No, Your Honor, I don't know if it was just stated on the record, but just what was stated in the plea form, that case then 1656 would be dismissed.
Yeah, it may.
But other than that, no, Your Honor.
All right. And have I complied with the court rule? Would it be proper to accept this defendant's plea?
We're satisfied.
Yes, Your Honor.
All right, court will accept in case ending in 1657. Court will accept the defendant's plea of guilty to this charge, and the other matter is dismissed. And does he currently have insurance?
No, I don't have that. I don't have that vehicle no more.
I also understand the defendant has at least one pending matter, maybe more than one pending matter in circuit court. So there's sort of other things happening.
So he's gonna be under the jurisdiction of another court.
That is correct, Your Honor.
All right. Any objection to the court proceeding with immediate sentence?
No, Your Honor.
No, Your Honor.
All right, sir, is there anything you want to tell me before I impose sentence?
No.
All right. Fines and costs of $300. When can you pay that?
I need at least a month.
All right. What I'll do is I'll make it payable by October 31st. Will that work for you?
Yeah.
Okay, pay it by October 31st, 2025, and I will suspend 365 days in jail.
Okay.
All right. Thank you.
Thank you, Your Honor.
Let's switch it up. We'll go back to Judge McNally.
The victim in now?
I want the victim, I want everybody. Give me that. David Istalart Gonzalez, 25W86565.
Good morning, Your Honor. Michael Paul, representing the defendant, stands to my right.
Name,
David Islar Gonzalez.
your name,
Mauricio Fernandez de Cordova, Your Honor.
and you are a certified interpreter in Spanish, correct?
I am, Your Honor.
Okay. And your name, Mr. Lucas.
My name is Carl Lucas.
What did you tell me when you came in the courtroom and I asked who you were?
Was an interpreter for this case, Your Honor. Mr. Gonzalez told me that he doesn't really need me. I called interpreter tonight, was, the request was for the first appearance.
Did you tell him that? Yes?
Yes.
You told me you needed an interpreter.
Yes, I can answer from all.
The whole courthouse has been telling me that you were capable of carrying on conversation with them. I don't know why you're smiling. No, no. When it's your turn to talk, I'll tell you. The entire courthouse has been telling me for weeks that you're able to converse in English. You told me you needed an interpreter. If you want to play a game, I'll somehow figure out a way to give you permission to put a badminton court out back here, and you play out there. Go have fun. You don't bring interpreters in here because you want to be a wise guy. You don't come into a courthouse and act like you need an interpreter when you don't need an interpreter. Got it? You got it? How disrespectful. How incredibly misleading and disrespectful, Mr. Lark. You know the good news about this? This upsets me. I'm not going to treat you worse, but you will pay for every nickel that the court's incurred and interpreted. You understand that? You want to play another game? Figure out how much his fee is going to be today. I'm going to release the interpreter, Lisa, please. I want that included as well. You guys take your time. Go back and see, go over the report. Maybe there's some kind of an explanation that he's been taking English classes since the time he was arraigned back in July, and suddenly, he's capable of speaking English. Maybe there's some kind of an explanation for all of this. I sure hope so. You've been a smug guy with me from the beginning, Mr. Gonzalez. Be smug? You can be smug. This is not the place to be smug. This is serious business. This is very serious business. Go out. You still look like you're smiling to me, and I just can't even imagine. I cannot even imagine somebody looking smugly at the judge with a smile on your face after the judge just discovered, after bringing in interpreter after interpreter, that suddenly you wise up and you admit that you can speak English. I watched him say, "Follow me," and you didn't even hesitate. My court officer here, half an hour ago, 20 minutes ago, were you in the courtroom? He said that, and it was abundantly clear, but it's been kind of clear before. But see, I find it so outrageous and outlandish that somebody would look a judge in the eye and tell them they need an interpreter if they don't need an interpreter. I'm going to give you the benefit of the doubt. I hope you enjoyed yourself. I hope you got a lot of money too, because these interpreter fees, they're not charging $22.12 an hour. Go talk to him, Mr. Crawford. Sir, you're released. Thank you very much. My sincere apology that somebody forced us to contact you and bring you in here when you had nothing to be here for. Go take your time. Here, give him this, please. I need to get off of this bench right now. Keep smiling, Mr. Istelar. Keep smiling. I hope you're enjoying yourself.
So the fact that Dad walked off the bench kind of says something right there. So I'm going to keep an eye on that situation. Let's go back to Judge Glazer for the moment.
Convictions, jail sentences is years.
You got a place to stay?
Stop talking.
Sir, do you have an address?
Going into the store, I didn't want you to talk about what happened in the store, that's all.
Sir, do you have an address where you live? Do you have an
No.
address or are you homeless?
Yes, I am homeless now.
Sorry to hear that. I don't know if TAP would take him. He has a conviction for the same stuff, 59 days. Earlier this year, actually has 2 convictions from this year. The other one was petty theft. But if he's gotten TAP before, they may not take him. Huh?
Was it in the same grant year? Well,
I don't think TAP's gonna take him because he has two in the same year, these convictions. I'll set a bond of $1,000. Good luck to you, sir.
I knew he was trying to stop me or something.
You gotta get some counseling, drug counseling.
A $5,000 bond.
1,000.
Thank you, ma'am. Thank
Good
you.
luck to you,
Good
sir.
luck.
Alberto Nunez Herrera, page 4.
Oh, by the way, I forgot Barbara. Thank you for the gifted membership. Very much appreciated.
It should be a 3rd-degree felony.
Your Honor, he'll need the Spanish interpreter, Your Honor.
Good morning, sir. You were arrested for grand theft of a vehicle. I will appoint the public defender's office for you.
Buenos días, señor. Usted fue arrestado por hurto mayor de un vehículo. Le designo a la Defensoría Pública para que lo represente.
Actually, sir, do you own your home?
De hecho, señor, ¿es dueño usted de su propia casa?
Rento un apartamento.
Okay.
I rent an apartment.
All right, public defender's office is appointed.
Bien, se le designa a la Defensoría Pública.
There's probable cause for grand theft of a vehicle, a 3rd-degree felony.
Bien, hay motivo fundado para hurto mayor de un vehículo, un delito mayor en el 3er grado.
He has recent grand theft convictions for different cases.
Él tiene fallos condenatorios recientes de hurto mayor en varios casos.
I'm setting your bond, $2,500. Have a nice day.
Le fijo el monto de su fianza en $2,500. Tenga usted un buen día.
A pagar 250, ¿no?
So I should be paying $250, right?
That is a contract between you and a bondsman. I don't know what they charge. I just set the bonds.
Eso es un contrato entre usted y un afianzador. Yo no sé lo que ellos cobran, yo solamente le impongo el monto de la fianza.
Gracias. Solamente para decirle a la jueza que el carro es mío, lo que lo puse a nombre de mi novia, pero el carro lo pagué yo, lo saqué yo en el dealer, todo.
Just to tell the judge that the car is mine, it's just that I put it in my girlfriend's name, but I paid for the car, I got it from the dealership.
You want to speak about privately with your lawyer about the facts of the case, sir, and any defense you have.
Usted querrá hablar, señor, en privado con su abogado acerca de los hechos en su caso y cualquier defensa.
Have a nice day.
Tenga usted un buen día.
They can't look away, huh?
Gracias.
Thank you.
Good morning. This is Mr. Yankel Mendez. You want a Spanish interpreter?
Please, Your Honor.
Yes. Sí.
Sir, good morning. You were arrested for fraudulent use of a credit card, unlawful possession of a stolen or credit or debit card, and fraudulent use of personal identification.
Buenos días, señor. Usted fue arrestado por el uso fraudulento de una tarjeta de crédito, por el uso fraudulento y posesión de una tarjeta débito o tarjeta de crédito y tarjeta de identificación.
So public defender's office is appointed for you.
Así que se le designa a la Defensoría Pública para que lo represente.
There's probable cause for the charges.
Hay motivo fundado para los cargos.
You are ordered to stay away from the Kohl's store at 2455 Northeast 10th Court in Homestead, Florida.
Se le ordena que se mantenga alejado de la tienda Kohl's en 2455 Noroeste 10 Avenida en Homestead, Florida.
You're not allowed to go to that store and you must stay away from there. Do you understand, sir?
No se le permite que vaya a esa tienda y debe mantenerse alejado de allí. ¿Entiende usted?
State, what do you want? Do you have an objection to tap state?
I'll defer to the court.
All right, tap alternate bond, $2,500 each count.
Bien, se le concede la libertad de la cárcel bajo el programa TAP, confianzas alternas, cargo 1, 2.500, cargo 2, 2.500.
Sir, you have to come to court for your arraignment on October 3rd at 9 a.m., courtroom 6-4, Judge Benzer.
Señor, usted tiene que presentarse en el tribunal para la lectura oficial de los cargos el día 3 de octubre a las 9 a.m. en la sala judicial 6-4 ante la señora juez Benzer.
Have a nice day.
Que tenga usted un buen día.
Next is Rodney Lopez Alaman.
I need the Spanish interpreter. Your
Good morning, sir. You were arrested for fraudulent use of a credit card and unlawful possession of a stolen credit or debit card.
Buenos días, señor. Usted fue arrestado por el uso fraudulento de una tarjeta de crédito y por la tenencia ilícita de una tarjeta débito o de crédito.
I will appoint the public defender's office for you.
Le designo a la Defensoría Pública para que lo represente.
Sir, how long have you lived in Miami?
Señor, ¿hace cuánto que vive en Miami?
Hace 3 años.
It's been 3 years.
Okay. Any objection to tap?
He's similarly situated.
Oh, it has an address, sir? You have an address where you live?
¿Tiene una dirección en donde vive usted, señor?
Sí, claro.
Yes,
Right.
of course.
Well,
13840.
I don't need it.
No la
Pretrial
necesito.
services, pretrial alternate bond, $2,500 count 1 and $2,500 count 2.
Bien, se le concede la libertad bajo el programa Pre-Trial Services, fianza alterna, cargo 1, 2.500, cargo 2, 2.500.
And stay away from stay out of the Kohl's store at 2455 Northeast 10th Court in Homestead, Florida.
Y manténgase alejado de la tienda Kohl's en 2455 Noroeste 10 Court en Homestead, Florida.
Have a nice day.
Que tenga buen día.
Gracias.
Thank you.
Maybe it's just me, let me know in the comments, but I find it humorous for some reason. It always strikes my brain as weird how these interpreters, when they're speaking Spanish or another language, they're so in that language, but then you get a truly American word or phrase or name or whatever, and all of that accent and all of that flow just immediately vanishes, and all you hear is American English. You know, they're going on in the Coca-Cola. You know, it always strikes me as weird for some reason. Let's go back to Judge McNally, where apparently it's now bring your animal to court day, so his day keeps getting interesting.
Officer Tolliver from Brownstown Police Department.
Your name, ma'am?
Amy.
Any offer here, if there's serious property damage accident or anybody is injured in any way, I can't take impeding. So you tell me, what's your offer?
We had not come to an agreement, Your Honor. I told her I would defer to the court. She was actually looking for, we did have a moment to speak. She was looking for the dismissal.
Okay, so you want to go to the hearing, ma'am?
Yes.
Okay, raise your right hands. You solemnly swear or affirm under penalties of perjury that the testimony you'll give in these proceedings will be the whole truth, so help you God, officer. You swear to tell the truth?
I do.
You swear to tell the truth?
Yes.
Go ahead. No, you go first. You got to tell me what happened here, July 23rd.
Approximately 17:15 p.m. There was an accident involved between two vehicles at Dix Toledo, just north of Carter Road. One car being occupied by Ms. Atkinson and her fellow passengers. It was originally pulled off on the side of the southbound Dix Toledo, north of Carter, so she can utilize her phone device.
He's pulled over on the shoulder?
Yes, sir.
Okay.
Then when she was done using her phone, she went to merge back into traffic, and another vehicle collided with her vehicle as she merged back into.
So the other vehicle was going southbound.
Correct.
Did the impact occur in the right lane?
Yes, sir.
And what did she tell you when you talked to her following the accident?
Ms. Atkinson?
Yes.
Ms. Atkinson said that she had pulled over to use this device, and then the other vehicle came out of nowhere as she's merging back into traffic.
What did the driver of the other vehicle tell you?
That the other female driver advised that she was southbound on Dix Toledo North Carter. And she did see this vehicle pulled over because Atkinson's vehicle pulled over on the side of the road. It was continuing at posted speeds when Miss Atkinson's vehicle just merged right in front of hers, causing the collision.
Okay. Do you have any questions of him, ma'am? Of the officer?
No, I just,
Go ahead, tell me your story.
I had just had a pacemaker implanted in my system and it was acting funny, so I had to pull over to use the phone device that runs the system. I pulled over to make sure that I was safe. It was actually an embankment. It wasn't off the shoulder. It was in a driveway, there was a fenced in area and it was a big enclosure, so I had plenty of room to pull off. I got done using my device and I went to come back out. I looked for my traffic. There was nothing there. I proceeded to pull out and I got hit in the passenger driver's tire. Even if
Wait a minute, passenger, the left side of the vehicle, the driver's side of the vehicle.
driver's side, rear tire.
Okay,
If that vehicle was there, I would not have turned out.
well, where'd it come from?
She just came out of nowhere, like she had either just pulled out of a driveway that was nearby. And she kind of where she was going faster than what she should have been. Either way, she just came out of nowhere.
Okay, she has the right of way. We have no evidence that she was speeding. She has the right of way.
They have all the cameras and all the things inside the black box. That was a brand new EV, Mustang. I have pictures of the accident. I have pictures of.
I'll be happy to look at whatever you have.
I have pictures.
I'll be happy to look at whatever. Let me see them. You can just pull the pictures up and he'll bring the phone up to me.
They start figuring. I'm not sure which way to like.
Yeah, but it is on Dix. The speed limit there is 50, right?
It's
45.
It changes as you go through. I believe it's in the round.
Yeah, but I don't know what these pictures tell me, except that there's some,
I was turning out and if she was there, she would have had time to brake. She would have had time to apply brakes. I literally, like, I covered the lanes. She came back on, yeah. If you see the way that she hit me, it was dead on. It was, there's no way that she hasn't been pulling out.
damn, she had the right of way. I'm sorry, listen. She has the right of way. I have no explanation for other than this, other than that she failed to yield the right of way. There's no way I'm an accident reconstructionist and I can tell by the damage to those vehicles that she was traveling in excess of the speed limit or anything else. I'm sorry, I'm gonna find you responsible as charged $195. You can go down the hall, you can pay that, and you can tell them you'd like to appeal that if you'd like, okay? You understand?
Can I at least get points?
I can't do anything on that. You said you wanted a hearing. I can't do anything with the points. I'm sorry.
As far as the money, is there any way that I can work that out there by going to jail or doing community service?
Do you work?
No, sir, I've been out of work since February. I'm dying. I don't have any money. I have nothing. I have more time than I do money, sir.
Do you have some note from a doctor?
My piece of paper right here, I have documents. I might have some in the car.
Do you have them here?
I have my pacemaker right here. I have.
Okay, you go get the documents. You go get the documents. And then we'll talk, okay? You get the documents, you bring them up here, I'll look at them and I'll talk to you, okay? All right? Fair enough? Relax. I'm gonna be fair with you. Just relax, okay? You're all set, officer. Thank you. Page 1, Maurice Guy Neely, 25F243, 946. 25F243, 246B. 25F243, 246A. 25F243, 246C. Your name? I'm sorry?
J1,
You gotta tell me your whole name, sir.
J1, G, B.
You have all this to pay? You owe 195, you owe 213, you owe 321 and 213. So I can do the math. You're telling me you have somewhere near $1,000? I thought you just said you had the money to pay all these. I can't hear you. Voice up.
Said that I had to pay. I was trying to pay it, but
Where do you work?
I don't.
Why not?
Never got it.
Did you graduate?
I was like,
You're not on disability, are you?
no.
So you owe 195 and 213, which is 395. That is 408 plus 321 is 729 plus 213 is 942. So how much do you have today? Why aren't you working?
Never, I can,
Did you apply?
yeah.
Where do you live?
Uh,
With who? Your older sister? You don't show up here. You haven't been here. I mean, these tickets are from January of 25. All of them are from January 7 of 25. You didn't show up for show causes. This one, I suppose, is from April 30 of 25. Your record's horrible. What am I supposed to do with you?
If you don't pay me, because I couldn't pay.
How are you going to pay this if you're not working? Tell me how you're going to pay it if you're not working.
I'll be doing helping my cousin, because she like
How much can you pay per week?
between 60 and 90.
I'll have you pay 40. When can you start?
By the end of this week.
All right. Lisa, I'm going to let you set up a payment plan on all these. You can print them out. I'm not going to write on these. You can set up 40 a week. I don't care which one's paid first, how you do it. And just set them up for 40 a week starting September 15th. I'll give you a little bit of leeway time. If you don't have the money, it's not a problem. You just come and talk to me on or before the due date. Or you call the court, we'll go on Zoom and I'll give you an extension.
Thank you.
But you don't ignore me. I don't like that. Don't ignore courts. That's a bad habit. People get in those habits. I don't understand it. Do we understand one another? I'll give you 49 extensions if I need to. But don't ignore me. Okay? All right, good enough. Cody David Reimer. 25W839281. Come on up. Your name?
Cody.
Sir, you're going to go right down to my judicial clerk. We'll bring the files down. I'm sorry, say your name again?
Cody David.
You're charged with disturb the peace.
Yes.
You have the right to a lawyer if you want one. Would you like one?
Yeah, legal, sir.
Pardon? I didn't hear you.
Yes.
Okay, we'll send you to a lawyer. And then either way, you're coming back in front of me, okay?
FC Hall.
Good luck. Do I have anything else down there? Pardon?
Nothing. I have nothing.
All right, well, he's between things. Let's go back to Judge Simpson and young Ronald Reagan.
I have an attorney, Mr. Gaddy now. I know the court knows for the record is employed by the Public Defender's Office. So this person may need a new assigned attorney. Because this is from 2016.
I thought that we had wrapped this all up the last time I saw you. I didn't, I wasn't aware that there was another meeting.
What do you mean?
I saw you at the end of what was it? Probably July. And we had I had pled to the other cases that we had and kind of
Well,
just
let's do
wrapped
this.
it.
Who was representing you when you appeared before me?
I didn't have an attorney there. It was probation who appeared.
Okay. I adjourn this to today's date. Do you want to be represented by an attorney on this, sir?
No, I think that this is such an old case, and last time we talked I had explained how I live in Massachusetts now.
No, I recall all of that, but
Yeah.
to try to get this resolved, do you want to be represented by an attorney? Because Mr. Gaddy is actually listed as the attorney on this case.
Oh, do I need one, or are we I'm okay with just pleading and or is that not an option this time?
It is an option. I'm not sure that it would be the most prudent or wise move, but I can't advise you what to do. So I'll ask you again, do you want to be represented by an attorney?
Sure. Yes.
I'll take that as a yes. This is a public defender.
Assistant Public Defender Natalie Pate with and on behalf of Robert Stevens. Your Honor, I would request an adjourned pretrial date, please.
All right. So this being a public defender case, I'm going to adjourn this out to September 17th, 2025, 2 weeks from today. This is a 2016 case, Ms. Pate.
Thank you, Your Honor.
So I'll adjourn it to that date, 9 a.m. Let's see if we can get this resolved.
And Your Honor, if I may speak directly to Robert Stevens, if you could call the public defender's office and give the best phone number for you.
Okay. Yep.
Right.
And who should I ask for again? I'm sorry.
You can just say, I need to give my phone number to Natalie, but the
Okay.
number to call would be 734
Mhm.
222.
All right.
You tell them you were just in front of Judge Simpson and you need to give Natalie your phone number. They'll put you in the right spot.
Okay. Thank you.
Thank you. Thank you, Your Honor.
Thank you.
All right, let's go back to Judge McNally because Mr. I need an interpreter, but I really don't is reapproaching from the looks of it.
Sir, please state your name for the record.
Name, your client pled to attempt MDOP back on August the 6th. The prosecutor dismissed the malicious destruction of property charge. I ordered a pre-sentence report. Have you had the opportunity to review the report with them, and are there any material additions, corrections, or deletion?
I've had the opportunity to review the report with the client, Your Honor, and there are no material additions or deletions that we requested at the time. I found that we can apply the recommendation, and we asked the court to adopt it.
Mr. Lucas, your name?
My name is Carl Lucas.
All right, so I'm going to listen to what they have to say. They're urging me to adopt the recommendation. I'm going to go on to Mr. Istelart Gonzalez, and then I'm going to ask you if you have anything to say, okay?
Yes,
Sir,
sir.
would you like to say anything?
You're speaking to me?
No, I'm asking Mr. Istelart Gonzalez.
Thank you, sir.
Is there anything you would like to say, Mr. Lucas?
I did submit a letter to the court demonstrating the damages that were done to my vehicle, and I paid to have those corrected. I just want reimbursement.
How much were the interpreter fees, Lisa? And I want you to estimate how much we're going to pay that gentleman today. I think it was $160 an hour. I don't know.
They charge $160 an hour with a 2-hour minimum and an $80 travel fee.
So that's $400 on my math.
Yeah, he's been here 3 times, so I figured it to be $1,200.
$15 months probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You change your address, your place of employment, your home telephone number, you must notify probation. You have to report as directed. You're to attend the anger management program with follow-up. You're to obtain and maintain employment, provide proof. I see that you are working, making $2,000 a week. You're not to have any contact with the victim, Carl Lucas. You cannot write, phone, see, text, email, or communicate with him in any way or have anybody else do any of those things for you on your behalf. You're not to possess firearms. You're not to possess dangerous weapons. You're to serve 4 days on the court work program. There's a $35 a day charge for that for a total of $140. You're to pay fines 100, costs 100, 75 victims' rights fee, $50 justice assessment. So fines and costs are 3 1/4. You have probation fees of 300, bring the total to 6 1/4. You have attorney fees in this case of $100, bringing the total let me just do my math here again. 3 1/4, 6 1/4, 7 1/4. You have court work program fees of $140 for a total of $865. I want to make sure that I'm getting the fees right, Lisa. You're to pay restitution through the court to the victim, Mr. Lucas. You're to pay through the court in the amount of $1,265.50. That brings your total to $2,130.50. You're to pay interpreter fees of $1,200. Your total here amounts to $3,330.50. If you violate, your probation could be revoked. You could be incarcerated for 45 days. You have 21 days to appeal. You have 14 days to apply for a court-appointed lawyer for purposes of appeal. If you violate, you're going to get 45 days, or you can get 45 days. Do you understand? Yes. Do you have all of this to pay? I'm not going to be very patient with you. Okay? How much do you have today?
$100.
I'm sorry?
$100.
You make $2,000 and you're single every week and you don't have more than $100?
See, earlier, it's outside.
I hope you've enjoyed this little experience. I cannot believe you did this. I know you're sitting there smirking again.
It's not going to be.
Pardon me?
It's not going to be.
Go ahead and appeal. And I hope the record's abundantly clear. Because you've had fun in the system, you have no respect for the system. Go ahead and appeal. Like I'm afraid. Give me a break. Go ahead and laugh all you want. You're going to pay $100 a week. And if you need more time, you're going to have to come in here and talk to me. Okay? Let's all have a good laugh. Let's all have a good laugh with Mr. Instalart Gonzalez, beginning September 15th. $100 a week. Thinks he's funny, huh? You better show up for everything, Mr. Gonzalez. You don't, you go to jail. That'll be funny, huh? Have a great day.
Just to be clear, his first $100 payment is due today, correct?
Yes.
So they're going to send a check
Yeah, we'll accept the check
or credit card.
or credit card, whatever you want. You get points.
Look at your card, look at it.
See what? What did he say, Mr. Crawford?
What you say, Mr. Esquire?
Come on back here.
Come on back here.
You're not gonna see me in court.
Oh, no.
No, you get to go in front of another judge and play with them for a while. How's that? Enjoy your journey through the criminal justice system. Mr.
I don't exactly know what to say there. This guy ends up back in front of McNally, and McNally's going to firmly put his shoe up that guy's rear end. That much is certain. The amount of disrespect, incredible. And this is, I said it earlier in the chat, this is a judge who's fair. He just doesn't, he wants you to act like an adult. So act like an adult. That's, That's incredible. We're going to keep an eye out for this guy, and this whole journey today will definitely be a standalone video here on the channel for sure. But yeah, that's crazy. Let's continue here for a little bit.
People against William Brush. William Matthew Brush, 25W8388383. I don't, Ms. Aycock, your name? Ms. Aycock? It's going to appeal. Yes. Good morning, Ms. Aycock. Your name?
Good morning, Your Honor. Leslie Aycock, on behalf of the defendant William Brush, who's present in my office to my right. Can you please state your name for the court this morning?
William Brush.
So I can give you 2 more weeks. Are we doing the 17th, Lisa?
The 17th at 8:45.
At 8:45, okay?
Would it be, I'm scheduled to be in person in front of Judge Hessen that morning at 10. Would it maybe be possible to come see you in person instead of by Zoom, maybe about like a little 9:15?
Oh, that's fine.
Okay, thank you, Your Honor.
9:15 will make it, okay?
Thank you very much.
All right, have a good day. Good luck, sir.
Thank
Your
you.
bond is continued.
Thank you.
Take care.
I'll make a note in person here.
Thank you, Your Honor.
Oh, can I see the papers? Good at papers. I just want you to see, get the papers first. Ma'am, just hand him the papers and I'll look at them, okay?
Excuse me. I have 2 doctor's appointments today, one at 4 and one at 1 o'clock. My aunt just took all of my other paperwork, things around to help me file for SSI.
Okay,
That's my-
let me recall the case. Amy Heather Adkins, 25B148-304. Your name? Look, here's what I'm gonna do. I can't tell from any of this. I mean, I see you're going through something, but I just can't tell. I'm just gonna give you 2 months to pay. And you can take back all your paperwork, and if you want to bring me other documentation, I'll be happy to set up a court date for you, okay? So I'm gonna give you until November. Lisa, can you schedule, I'm gonna give you till November 3rd to pay. And if you have something that you want me to look at, I'll be happy to do that for you, okay? But I can't tell from that.
Well, just so you know, this is my husband, all I paperwork, showing that I'm out of date. These are the check stubs that I
Okay, and I hate to be so morbid about it. Please listen, I have people lie to me all the time.
don't have anything to lie about, sir. I have enough.
No, I understand. I'm not saying you are, but I need some documentation, strangers at
This right here shows that I had the implant
Okay,
on that date. Like, this is my implant card.
what do you want me to, ma'am, I can't just waive your fines. You said something that was very traumatic. I can't just waive your.
All I'm asking. Can we do community service or jail time?
I'm not gonna send you to jail on a speeding ticket, man. Or a failure to yield ticket. I'm not gonna do that. You wanna do community service, but I would think if the medical condition has risen to the level it has, that you wouldn't wanna do community service either, right?
I have no problem feeding people. I do it for community.
I'll tell you what, you wanna do community service, I'll let you do community service. Defendant may pay fines and costs of $195 by November 3. or perform 14 hours of community service by November 3. Okay? So either one that you choose to do is up to you.
So much. Did I just bring the proof back up here?
Correct. Okay? Best of luck to you. I wish you well. Good luck. Thank you. Ramel Libertus, Howard Jr., 25W8388526.
Good morning, Your Honor. Shall you forget my final purpose?
Sir, your name? For purposes of arraignment, does he stand mute and waive formal reading?
Yes, Your Honor.
Not guilty, please entered. $500 postal bond. You cannot leave the state without the consent of the court. You cannot violate any law. You must appear in court as directed. Do you understand that? Said he kicked an officer too. No contact with the victim or prosecution witnesses, okay? I'm not saying he did that, but that's the order of the court. No contact with the victim or prosecution witnesses. Okay? They're going to give you a new date, by the way, and you're going to have to fill out a petition for a court-appointed lawyer. Do you work? Why are you guys working? I don't understand why people aren't working anymore. I got everybody coming in here, it seems like, not working. I don't want to overgeneralize by saying everybody, but I don't know how people eat. Some do. There must be some secret out there. We doing the 17th, Lisa?
Yes, 9 o'clock.
At 9 a.m., September 17th at 9 a.m. So you're gonna have to fill out a petition for a court-appointed lawyer. Go down the hall, get your notice, and we'll see you back here that day. Any questions? All right, best of luck. Gabriel J. Frank Young, 25W839-444.
Well, good morning, Your Honor. Chris Bishopke, here we have my client, Atrocious.
Sir, come on up here, state your name.
My name is Gabriel J. Frank Young.
Does he stand mute, waive formal reading?
Yes, Your Honor.
He's gonna plead to the civil infraction, the expired plate, the improper plate will be dismissed, right?
That's accurate, Judge.
You go to get that two-man-shoe going on there with you. Huh?
Judge, I'm just trying something new.
It looks good. Looks good on you. It makes the good-looking guy look better.
That's what I show.
You want to plead to civil infraction?
Yes, sir.
To that charge of expired plate, responsible or not responsible?
Responsible.
All right, I'm dismissing the misdemeanor, accepting your plea. 150 is the total. You can go down the hall and take care of that, and you're all set.
Awesome, thank you.
Best of luck. Gomez. Shayla Nicole Gomez, 25W839-237A and B.
Good morning, Your Honor. Chris Bishopke, here we have my client's time to send that held person has the agreement wait for reading my client's case.
Ma'am, your name?
Shayla Nicole Gomez.
I'm entering a not guilty plea for purposes of arraignment. She's going to plead to impeding. They're going to dismiss the suspend, and she's going to plead to expired plate as opposed to no plate, right?
It's my understanding that they're dismissing the driver license suspended and the no plate, and then she's just pleading to an impeding traffic. She has a valid plate and
I see.
she has a valid.
I see. Dismissed per step. Okay, my apologies. You're going to plead to a civil infraction of impeding, right?
Under my counsel's,
Is that what you want to do, though?
quite frankly, no.
Well, then go.
Just read the memory call.
Hang on a second.
So I.
Wait, just wait. She came up here before and she told me she had a valid license on July 26th.
Judging, it's being dismissed, so it's not really a point of my concern.
Right.
But the plate was not valid, and then the prosecution is dismissing the civil infraction and going.
I just purchased the.
Ma'am, don't interrupt your lawyer. You don't have to do anything. You can go to trial on the driving on a suspended. Maybe they'll move to dismiss that then. And you can go to a formal hearing on the plate violation. So if you don't want to do this, what your lawyer worked out, you don't have to. It's up to you.
I have a great deal of respect for the court's time and your time, sir.
Don't worry about my time. Listen,
I am,
listen to me.
severely
Hang on.
financially.
Hang on. Don't worry about my time. This is what I do for a living. I chose to do it. I still enjoy it. Do not worry about my time. Did you have a bad plate? You didn't have a plate.
I did not have a plate at all. I had insurance. I just bought the car that day. I have a clearance on from the court, from Woodhaven saying I had a license on the 22nd. I had,
Okay, so listen.
Judge,
What?
I just noticed that the B case is paid. She made a
Paid?
payment online.
Is that true?
yes, yes.
Oh, call in the prosecutor for me. Did you know that? You didn't.
I've simply paid so
All right.
much. I feel like.
All right, slow down. Come on. We're not that bad here. Just relax. Just relax. You haven't, would you pay $135?
I have receipts here,
No, on this, on these, you didn't pay $600 on these cases.
135, Judge.
I have 3 different cases all.
Oh, okay, but the different incidents, I mean, come on. What were those for?
So I had experienced a end of a very harsh marriage. I wasn't aware that my insurance was not being paid. It was supposed to be. So
Hang
I
on
had
one
to do
second.
that.
Mr. Urich, your name? Your name?
Good morning, Your Honor. William Eric on behalf of the city of Woodhaven.
So she paid the expired plate.
Right.
Your Honor, in this circumstance, may I propose to be a potential for my client to have the driving license suspended, dismissed. She's already paid the B ticket, and then keep the traffic not.
Do you want to do that?
That's fine, Your Honor.
You change the stip form.
Of course.
That's fair, I think. I mean, if you paid the expired plate already, there's no reason for us to belabor this as far as I'm concerned. All right, so is that what we're doing? Is you're moving to dismiss, to suspend? And I'll just make a note, Mr. Urich, defendant paid file B, $135. So that acted as an admission. So you pled responsible by paying it and sending in your citation, okay? Well, I just want you to understand that conviction will enter. I'm dismissing the suspend, right, Mr. Urich, altogether?
Correct.
I've actually paid for that one as well. If there are any
You didn't pay for this suspend.
$230 of the. Yeah.
On this case?
That was a
I paid that
2024 case that was in warrant status.
That had nothing to do with this case, just so you understand.
It's worth the try.
All right, well,
If it was getting suspended and they had to pay for the.
the suspend charge is dismissed, okay? On this case, you're all set. You're confusing a lot of cases. You got to make sure you understand which case you're talking about, okay?
I appreciate your being so gracious.
Good luck to you.
Thank you.
Jeffrey Wasilewski, 25W839-262. Come on up to the podium, sir. Your name?
Jeffrey Wasilewski.
You have the right to a lawyer. You're charged with assault and battery. I'll be happy to provide you with a lawyer. Would you?
I have to pay for my own lawyer. I think I make too much money to.
No, I'm just telling you for purposes of arraignment, I have to offer you a lawyer. And I can give you a court-appointed lawyer, or if you want, I'll be happy to give you an adjournment for a couple of weeks so you can go and hire your own lawyer. It's up to you.
It's up to you.
No. I can't make that determination for you. I'm either going to adjourn this 2 weeks so you can, look at me, sir.
Yes.
I'm either going to adjourn this 2 weeks so you can hire your own lawyer, or I'm going to give you a court-appointed lawyer today for purposes of arraignment.
I'll hire them.
Okay, Lisa, we're going to adjourn this a couple of weeks, okay? I'll just make a note, defendant will hire attorney.
You want me to plead back in?
I'm not even going to arraign you right now. I'll let you go and hire your own attorney and we'll adjourn this to September 17th
9:15.
at 9:15. You stay away from the victim. You understand me, sir?
Sure. How do,
Hang on. One thing I probably should do is I'm gonna go ahead and arraign you, okay? I will arraign you. I'll explain your rights. I'll set a bond. I'll explain. Just relax. I'm not gonna do anything to affect you negatively. I'm going to give you a personal bond, but I'm just telling you, I will arraign you unless you want me to give you a lawyer for purposes of arraignment.
no, arraignment, that's what you gotta do, that's what you gotta do.
On August 5 of 25, the police think that you did commit the offense of assault and battery by assaulting and battering your neighbor, Mrs. Slayton. That is a misdemeanor, punishable by up to $500 in fines, 93 days jail, court costs for all of those penalties. Do you understand that?
Yes, I know.
And did you sign the advice of rights form and read it and understand it?
Yes, I know.
If you plead guilty, you'll be given all those rights, and there will not be a hearing or a trial of any kind. You understand that?
Yes, I know.
All right. So I'm going to enter a not guilty plea for you. You don't have to post any money. I'm giving you a $1,000 personal bond, but you don't have to post any money. So again, you cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed, starting with September 17th. You have to go and get fingerprinted. No contact at all with the victim in this case, Mrs. Slayton, whoever that is. You cannot write her, phone her, see her, text her, email her, or have anybody else do any of those things for you or on your behalf. That's actually Tammy. Just let me finish, sir, please.
Well, yeah, thank you.
This is just an arraignment. You shouldn't say anything right now. You want to talk to your lawyer and let your lawyer take care of everything, okay? So no contact with Tammy Slayton, no contact with prosecution witnesses, no firearms. If you have any firearms or dangerous weapons, you have to surrender them to the Woodhaven Police Department, and you have to go over and get fingerprinted and photographed by 11 a.m. today at the Woodhaven Police Department. Do you understand that?
Yes, sir.
Now, I don't want to be accused of not letting you speak. I'm telling you, I don't think it's in your best interest to speak.
Okay.
If you want to tell me something, I'll be happy to listen to you, but I don't think it's in your best interest to speak. You shouldn't even admit you were in a scuffle or anything else. I'm not saying you were, sir. I just.
I can't, I'm my own pocket.
Okay, well, then you're certainly gonna have a self-defense argument. There's no question about that. Talk to your lawyer about all of that, okay?
Yep.
And then go down the hall and get your notice. We're gonna give you an order for prints. You have to go over to Woodhaven and get fingerprinted, okay?
Yep.
Good luck to you.
Okay, so-
You too. I wish you well. Thank you. Richard Allen Hanley Jr., 25W838922. I'm gonna take that next with you there, Sergeant Driscoll. I'm gonna finish this one up and then I'll come back there. Good morning.
Good morning, Your Honor. Stephen Shark on behalf of Mr. Hanley, nice to see you, Judge.
You too. How are you? Your name, sir? All right. I'm going to go ahead and take the plea. This is the plea is charged to OWI, right?
Yes, Your Honor.
Is that what you want to do, Mr. Hanley?
Yes.
If you plead guilty here, the possible penalties are up to 500 fines, 93 days jail, 360 hours community service, court costs are all those, 6 points, license suspension or revocation in accordance with your record, and your vehicle could be or might have to be immobilized depending upon your record. Do you understand that?
Yes, sir.
And did you sign, read, and understand the advice of rights form here today?
Yes.
If you plead guilty, you will be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes.
All right. Do you have any questions before I go on?
No.
This is a second offense, right?
Yes, sir.
To the charge operating while intoxicated, how do you plead?
No.
Were you operating a motor vehicle in the city of Woodhaven, county of Wayne on Allnear West at 2:06 in the morning on July 20 of 25?
Yes.
Did you drink alcohol prior to that? And if so, what did you drink and how much?
Yes, sir, I get you, I'll prefer that, we got,
What-
bears,
How many?
probably 3 or 4.
How big were the bears? I can't hear you.
There was, the bugs, like the glass bugs.
I know, but were they more than 12 ounces? Were they 30 ounces?
Yeah.
So take a stick with his blood alcohol is 0.15.
Okay, why were you pulled over by the police?
I think that I was speaking.
Do you think you were speeding, and you think you were speeding at least in part because of your alcohol consumption?
Yes,
Counsel, the results were, this was a breath test, was it?
Yes, Your Honor.
And the results were 0.151 I have.
Yep, that's correct.
Can you so stipulate that was accurate for purposes of the plea?
Yes, Your Honor.
Are you on probation or parole right now, sir?
no,
Has anybody forced you to plead guilty?
no,
And accept your plea, I find it to be an accurate plea, made voluntarily and understandingly. Please accept that I do have to immobilize his vehicle. He owned it, so he has to be completed. I'll give you the minimum immobilization period, 90 days, and it has to be completed within 7. So by September 10th, you have to have that vehicle immobilized. My judicial clerk will prepare an immobilization order. I'm going to sign it, and you just have to have that club put on the steering wheel. Counsel, I see he had one that was nollie prossed back in 17. Does he have any desire to, and that's fine, so I'm not counting that. I'm just asking, does he have a problem that merits sobriety court?
That's the part of the case.
I want you to talk to him about it.
Yeah.
And if,
He probably would, Your Honor.
pardon?
He probably would be interested.
You got 5 minutes to talk to him about it now? I want to send him over to probation and make sure he understands the program.
Okay.
And then you guys come on back in here. John, take him over there. I'm going to give him a screening and he's going to be screened and assessed today. And I want him to find out about the program. You don't have to sit around while he's screened.
Okay.
But at least come back in and, because the sentence date's going to be different depending on whether he gets in sobriety court or not. So I'll let you take the file over to probation.
Okay.
We're gonna, in either way, you tell him I'm just Judge sent him over there to see if there might be an interest in sobriety court, okay?
I'll meet outside. Okay, thank you.
Thank you very much. I'm gonna real quick take Robin Boynton the second. Robin Lewis Boynton the second, 25W839319. B.
Good morning, Your Honor. Mr. Chairman, you're going to get my client's name, set the matter, being held in person, as the agreement will read my client can speak.
Your name, sir?
Wood.
Now he's gonna plead to no ops, to suspend to be dismissed, right?
Correct.
You gotta get a new license, valid license. You understand that? If you plead to no ops, possible penalties were up to 100 fines, 90 days jail, costs are all those. Do you understand that?
Yes.
And did you sign, read, and understand an advice of rights form here this morning?
Yes.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or trial. Do you understand that?
Yes.
To the charge, no valid operator's license on person, how do you plead?
Yes.
Were you operating a motor vehicle on July 25 of 25 in the city of Woodhaven, County of Wyndham?
Yes.
Did you have a valid license with you on your person? Are you on probation or parole? Are you on probation or parole?
Yes.
Were you on probation on July 25th?
Yes.
By pleading guilty here, this would be deemed a violation of that probation. That probation could be revoked. You could be incarcerated on that charge as a result of this plea and conviction. You understand that?
Yes.
You still wish to plead guilty?
Yes.
Get both your search warrants. Has anybody forced you to plead guilty?
No.
I'm gonna accept your plea. I'll accept the no ops. Dismiss to suspend. I'll sentence him now. Anything you'd like to say?
Your Honor, just that my client was under the mistaken notion that the restricted driver's license, however, it is suspended till the end of the year. You understand it's going forward. That the Secretary of State and what was ordered in court are two different agencies of government. He understands it won't be duplicated in the future.
Sir, anything you'd like to say?
No, Your Honor.
Can't drive on a suspended license. 100 fines, 70 costs, 75 victim charge, $50 justice assessment, 295 or 60 days. Can you pay that today?
Yes, I can.
You go down the hall, pay that, and we're all set. Any questions?
Yes. Do they take, credit card?
Yes.
Okay.
Okay?
Okay.
Best of luck to you.
All right, thank you.
Thanks. I'll send them right out as soon as I read these guys.
All right, we're creeping up on lunchtime over in Florida, so let's see how Glazer's holding up for a few minutes.
Have a nice
Thank you.
day.
Bien, se le impone fianza para el cargo 1, $5,000, cargo 2, $5,000 y $250 para el cargo 3. Tenga buen día, señor.
have another case?
¿Qué pasará con
The other one I did 5,000. It was also a battery, spat on a deputy.
pasará con mi deportación?
So what will happen to me in terms of my deportation?
I don't know. It's up to the state to decide if they're going to file criminal charges and you don't have an immigration hold even.
No sé, depende de la fiscalía si lo van a enjuiciar por cargos penales y aparentemente usted ni siquiera tiene una retención de inmigración.
You should speak to your lawyer. Good luck to you, sir. Have a nice
Usted
day.
debe hablar con su abogado, señor. Buena suerte, que tenga buen día.
Next is, Mr. Chair, I'm sorry, I got to read the stay away order. Sorry. Bring him back real quick. Sorry, I might have to order that you stay away from Oscar Rondan, the alleged victim who you punched.
Disculpe, también tengo que ordenarle que se mantenga alejado de la presunta víctima a quien usted le dio un puñetazo, Oscar Rondán.
No contact with that alleged victim, and you must stay at least 500 feet away from his home, school, and place of employment. Good day.
No puede tener contacto con esa presunta víctima y debe mantenerse a un mínimo de 500 pies de distancia de la persona de la víctima, su casa, centro de estudios y de trabajo. Que tenga usted un buen día.
Tengo una pregunta. ¿Cuánto me dictarían mi sentencia penal? Pues, ¿cuándo voy a traer al corte? Para saber cuánto.
Well, when would I be sentenced? When do I need to come back to court? Just so I
So
know.
you'll see a judge in 21 days for the arraignment, and it's up to the state attorney's office to file criminal charges.
Usted va a ir ante un juez en 21 días para la lectura de los cargos y depende de la Fiscalía Estatal del gobierno el presentarle cargos.
You can use the free phone at the jail to speak to a lawyer at the public defender's office.
Usted puede utilizar el teléfono gratis en la cárcel para hablar con un abogado de la Defensoría Pública.
All right, let me have Dennis Jones, page 12. Bond out. Chad Menon. Good morning, sir. You were arrested for false imprisonment and battery by strangulation. Sir, can you afford to hire a private lawyer?
Yes.
All right, the victim's here too. Sir, do you have a lawyer present, or do you want me to reset the case in the afternoon to give you a chance to have a lawyer? Or do you want to waive a lawyer's presence and I can proceed now?
I guess
Your choice, whatever you like.
whatever's best for me, myself, I guess. I don't know.
So if you don't tell me what you're gonna do, I'm gonna reset it for the afternoon. You want me to waive a lawyer's presence, or you want me to reset it to give you a chance to have a lawyer be in court with you?
I'll take the lawyer's presence, I guess.
Okay, reset it in the afternoon. Miss Moreno, come back. He wants to, or I can hear from you now.
Yes, ma'am. Yes, I'm here.
Hi. You want to put on your video?
Hi, Your Honor. Yes. Am I here?
You got accepted promotion as a panelist. Can't you put on your video if you can?
Can I take the one for now, please?
I already wrote later. You should have answered sooner.
I'm sorry. I'm just not too used to it.
It's fine. Of course I can do it now. I'm trying to get the victim here. I don't know if she wants a stay away order. Miss Moreno, you there?
I'm
Hi,
here.
good morning.
Hi, Your Honor.
Raise your right hand to be sworn, please. Do you swear or affirm the testimony you are going, the right hand? The other hand?
Yes, ma'am.
You raise your
So
other
sorry.
hand. Do you
Yes.
swear or affirm the testimony you are going to give in this proceeding will be the truth? If so, state I do.
Yes, ma'am.
Okay. Please tell me your name.
My name is Gloria Moreno.
Are you afraid of Mr. Mannon?
No, absolutely not. We have been together. It was just a stupid situation that happened. He's been receiving anger management therapy along with therapy
All right,
itself.
just listen to the question, okay? Do you want the court to
Yes, I'm
order
so sorry.
Mr. Manning to stay away from you?
No.
Are you two living together?
Yes, we are.
Okay, thank you. State any questions?
No questions, but I would like to note, this is not the defendant's first domestic violence arrest.
It's from
He
July.
got arrested in 2015 and 2020.
There's
Yeah.
probable cause for the battery by strangulation. Let me just see the, was it false imprisonment? Let me review that.
It said she walked towards the door to leave, but the defendant blocked her path, shoved her
Okay.
to the ground, prevented her from.
All right, there's probable cause for the charges. So, Mr. Manning, I'm going to enter a modified stay away order from the alleged victim, Gloria Moreno. You are allowed to have contact with the alleged victim, Ms. Moreno. You are prohibited from being physically threatening or violent towards her in any manner whatsoever. So only friendly, nonviolent contact is allowed with the victim. Do you understand, sir?
Ma'am.
Do not engage in any criminal activity. Do not use or possess illegal drugs. And
Yes,
do
ma'am.
not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. Do you understand the modified stay away order?
Yes, ma'am.
Thank
Yes,
you.
ma'am.
Ma'am, do you have money to post a bond for him? Can you afford to
Yes, we
post a
do.
bond? All right, count one false imprisonment is $1,000. Count two battery by strangulation will be $4,000. All right, I set a
Thank you, Your Honor.
5,000 total bond. I lowered it a little for you. Good luck to you. Have a nice
Thank
day.
you so much, Your
Appreciate
Honor.
And sir, make sure to hire a private lawyer to come back for your next court date. It should be, I
Yes,
think,
ma'am.
in 30 or 60 days. You'll get notice in the mail.
Oh, well, God bless you. Thank you.
Thank you.
Thank you, Your Honor. God bless you.
Thank you.
Next.
What? Next is Anton Ellaby. Who do you want next?
Yeah.
Good morning. Mr. Ellaby, you were arrested for one count of first-degree murder. And I will appoint the public defender's office for you. Who are you, ma'am? Your mother's in court. So this is from August 20th. Let me review. We saw the co-defendant earlier who was charged with like accessory after the fact, I think. Let me see this, read this arrest affidavit. Okay, I had a chance to review the arrest affidavit. I believe there is probable cause for the charge of first-degree murder. And Mr. Wilson, are you going to invoke your client's rights?
Yes, Your Honor. We do have a probable cause argument. He is charged for this murder in the first degree. On page 2, Your Honor, that second paragraph, lines 2 and 3, stating that some of the males next to the defendant produced firearms and began firing upon the deceased victim's direction. Defendant was observed running away in close proximity with the shooters in the same direction. Doesn't say that my client fired a firearm, had a firearm. If the state is trying to go with the principal theory, doesn't say he even had knowledge of what was going to happen, and just being in the mere proximity is not enough. But it doesn't state in any way, shape, or form that he did any of the shooting or did anything to further the shooting, buying the firearms or anything like that.
Okay, you have to read the whole arrest affidavit. He was seen there shooting, or I'm sorry, he was seen with in the area where the shots were fired. It says some of the males next to the defendant produced firearms, began firing upon the deceased victim's direction. He was observed running away in close proximity to the shooters. And then when he was arrested later, they found 3 handguns, 2 AR style pistols on his person, and also ammunition that does match some of the calibers recovered from the shooting scene. So I think that's enough at this point for purposes of the charge of
Your
first
Honor,
degree
I
murder.
believe in the, I'm sorry, I believe in the co-defendant's arrest form, they were saying it was in her possession. Now they're saying it was his. I just want to double check that arrest form, because if so, then they're writing the identicals to both of them, saying it was in both their possession.
Mhm.
Yes, Your Honor, on Eileen Garcia, who was number 1 on the calendar, page 2 of her arrest form, second to the last paragraph. No, I'm sorry, the last paragraph. Total of 3 handguns and 2 AR style pistols were located on the defendant's person. So they said that in hers and they're saying it his. So clearly, I don't know what the officer is trying to achieve, except probable cause, but it can't be on both. Your Honor already found probable cause on Eileen Garcia this morning.
What did I find probable cause for her for?
Accessory after the fact, Your Honor. But
What is your client charged with?
Murder in the first degree, Your Honor, but using the same set of facts about who the firearm is on. It can't be on both. You just stated that it was alleged to have been on him based on what this officer wrote. The same thing on Eileen Garcia. It can't
You know, Miss F, that he's charged of first degree murder. You don't think your officer should come in here and give us facts that are precise as to what this alleged defendant did?
I can bring the officer in, Judge.
Yeah, call him up. Let's go.
Let me see if the officer's available. Hold on.
Just so we're clear, I believe this arrest affidavit does mimic very similar facts to what Miss Garcia's arrest affidavit.
Yeah, another one.
Is somebody else? Oh, okay. That's his brother. Both of your boys? Yeah, it says the brothers were involved. It mentions the. What I read is Traquan Williams was the shooter. That's what I thought I read in the female's affidavit.
So Judge, is it okay if the detective appears at 1:30?
Yes.
Okay. Let's reset it for a PCH, Judge.
Just let me finish reading this.
Sure.
Just I want to be clear, it says some of the males next to this gentleman, next to Mr. Ellaby, produced firearms and began firing upon the deceased victim's direction. He was observed running away in close proximity.
Judge, we'll bring the detective in to clarify everything.
There may be an issue as to Mr. Ellaby, so I'm resetting it for the probable cause hearing, and I'm not going to find probable cause at this time.
And we can also reset Mr. Williams.
Let me call up Mr. Williams. Just give me a minute though for Mr. Williams. I don't want to keep him separate from Williams. I think it's his brother. Corrections? Keep Mr. Ellaby separate from Mr. Williams.
Yes, Your Honor.
All right, let me call a different case. We'll see you at 1:30, sir, for a probable cause hearing. Ma'am, if you have a seat, I'm gonna call Mr. Williams next. Do you have, who is this now? Mr. Williams?
Yes, Your Honor.
Hey, Mr. Williams, sir, good morning. You were arrested for 1 count of first-degree murder, 5 counts of attempted felony murder, 7 counts of criminal mischief, and 1 count of discharge of a firearm outdoors or in a residential area. And I just want to be clear, the charge of first-degree murder is a capital felony. So I will appoint the public defender's office for you. Your mother's in court as well. Good morning, ma'am. So I think let me review this arrest affidavit.
Judge, regardless, I'm gonna bring the detective in.
Okay. So Mr. Williams was identified as the person involved in the shooting. He was observed wearing the same clothing from the Hialeah shooting to North Miami Beach shooting, along with other items of evidentiary purpose. So this arrest affidavit reads a little bit different. Would you want me to set this in the afternoon as well?
Yes.
Okay, the state's asking me to reset it in the afternoon. We're bringing the officer in. We just want to be clear on who should be properly charged with first-degree murder. Okay, sir? So we'll see you at 1:30. Okay? And Mr. Wilson? You invoking his rights to counsel?
Yes, Your Honor.
Okay.
Your name, sir?
Chauncey Moore.
All right, next we have Chauncey Moore. I'm sorry, Renee. Yeah, hi, Mr. Moore. Good morning. You were arrested pursuant to an arrest warrant charging with armed robbery with a deadly weapon. I will appoint the public defender's office for you. Let me review for probable cause. It's from August 14th. I'm just reviewing this arrest affidavit. It happened at the Aventura Medical Tower parking garage. So the victim, who's wheelchair bound, was going back to his vehicle when he's approached by a black male. He said the black male had come walking down the east ramp after rounding the corner. He thought he was going to ask him if he needed help, since usually people offer to help the victim in the wheelchair. He then approached him from behind as he had one leg in the vehicle and said, "Let me get your chain up off you." When victim turned around, he observed a knife being held to his left side near the back of his rib area. And he said, I guess he was told, the victim stated he went to take his chain off, and the subject stated to him, "Take all of that off." He took his necklace off, and he noticed a Rolex watch and a wedding band, and he had also a pendant, St. Lazaro pendant, and he took all of his jewelry and fled. There's CCTV footage at the property. It wasn't working properly at the time of the incident, but the areas had, there were surrounding buildings that had CCTV footage. So there's no luck in the results there with CCTV. So they had CCTV footage from city cameras. And it showed a black male, medium build, bald, wearing a white t-shirt, tan cargo shorts, white sneakers, backpack, walking through the Marathon gas station. Then walking through the bank parking lot to a bus bench. They have CCTV footage from Aventura Hospital. So the officer was able to get a clear visible screenshot of the subject as he entered the building A. And he was able to identify Mr. Moore. There was a photo lineup done. And the victim was able to positively identify, the victim who's wheelchair bound was able to positively identify Mr. Moore as a subject. He used a knife to steal his jewelry or rob him of his jewelry. There's probable cause. So you are ordered to stay away from Christopher Heredia, the alleged victim. No contact with the victim, either directly, indirectly, in person, in writing, by telephone, or through third parties. No contact with the victim through social media or other electronic means. And you must stay at least 500 feet away from the victim, his home and school and place of employment at all times. And he's ordered to stay away from the Aventura Medical Tower parking garage at 2801 Northeast 213th Street in Aventura, Florida. So I'm going to grant the state's motion for pretrial detention pending final hearing pursuant to Florida Statute 907.041. I'm holding you with no bond. You will see a judge tomorrow, and that judge will set a final hearing on the state's motion for pretrial detention. Good day, sir.
Crazy, I didn't do this shit.
That's not what the video said. The surveillance video said, or the victim. We're done with the morning calendar, right? See y'all at 1:30.
Thank you.
All right, good for her. She's done with the morning calendar, only 15 minutes past lunchtime, so she should be real happy with that. So I've got a fun place for us to go, but before we go there, let's do that thing we do and talk about our sponsor, Aura. So yesterday, when I talked about Aura, and here's Ellie again, she hears the word Aura and she comes running. I talked about how Google had sent me an email that I had been compromised through an incident they had with Salesforce. Well, it turns out that incident didn't just stop there. I also got an email last night from Cloudflare telling me they were part of the same incident, only there they not only lost like basic information, they apparently also lost things like API keys and different security credentials and stuff like that. So things that are very bad. So look, we know from experience, because you guys have received emails like this, I know you have, because we all do, telling us that our information has been compromised. But we know through that, and we know through the courts that we watch and everything else, that people get a hold of your information, and it's a very, very bad, not good thing. But this is where Aura comes in, because Aura is a one-stop shop for protecting you online and keeping you safe. Not only do they find the bad actors, the data brokers, and everybody else who has your information and work to get that offline for you, but they also have identity protection, 24/7 monitoring of your financial situations. They've got a VPN, antivirus, parental controls, you name it, they've got it to help keep you safe online. Now look, we can pretend all day long and twice on Sundays that this stuff does not happen, but it does happen. All of our information is out there. If you don't believe me, just Google yourself and see what you find. That is what Aura challenged me to do when I asked them to prove it before I would agree to partner with them. And I did, and the information was frightening, and then they said, now let us show you what we can do. And then my information started to disappear from being online. So they know what they're doing. Give them a try, seriously. Aura.com/TCF. It's 14 days for free. That is more than enough time for you to find out exactly what it is that they can do for you, exactly how they can help. Honestly, you'll see in the first 24 hours everything that they can do for you. So there's really no reason not to give it a go. If it turns out it's not for you, no big deal, but I'm willing to bet you'll find that it's a big deal and it's worth it. But give it a try. Aura.com/TCF. Again, you get 14 days for free. Protect yourself online. I do, especially now that I've seen what they can do for me. And also support the people that support the channel. Aura.com/TCF. Okay, so let's go to Reno, Nevada. We went there a couple of weeks ago. Shush. We liked it. Let's try it again. This is Judge Shelley O'Neill.
Responses. I'll go over your charge. I'll ask if you understand the charge, and then I'll take your plea. You know, from talking to the lawyers that you have three options here this morning. You may enter, each of you here today who is making an initial appearance are presumed to be innocent, which means that you have an absolute right to enter a plea of not guilty and schedule the matter for trial. All trials are held in person at the Reno Municipal Court, which is located at 1 South Sierra Street in Reno. They're usually set within 30 to 45 days. If you want it set out longer, you can speak with your lawyer about waiving your speedy trial rights. If you're charged with a serious offense this morning, such as DUI or domestic violence, I will strongly urge that you enter pleas of not guilty. I'll ask if you can afford your own lawyer. If you cannot, I will appoint a lawyer to represent you, and I'll do something unusual. I will order that you make contact with the lawyer prior to the trial date, so you may be prepared, so the two of you may be prepared to proceed to trial. No good trial lawyer can be ready to go to trial if they've not met and discussed the facts and circumstances with their client. You'll be given, if you're not given the contact information for your lawyer today, you may contact the Reno Municipal Court and get the information, both telephone number and email address of your assigned lawyer. We have that available for you. If you are going to enter a plea of guilty or no contest, guilty tells me you want to accept full responsibility for your offense. And no contest tells me that you don't want to challenge it in court. You're not going to contest the charge. I will tell you that there is no difference in sentencing between a no contest plea and a guilty plea. And I'll go over your constitutional rights and possible penalties with each of you individually. I will advise you that I'm required by Nevada law to ask in the canvas, which is a question about your rights and the possible penalties, if you've served in the United States military. I do that for two reasons. The first is because the state of Nevada requires it as they're keeping track of veterans in the criminal justice system, but also more importantly, I believe, because we offer at the Reno Municipal Court a treatment court for veterans who have serious mental health issues or substance use issues. It's called CAMO Reno. It stands for Courts Assisting Military Offenders. If you're interested in that program and you are a veteran, please speak with the legal defender and they can steer you in the right direction. That being said, I will also remind you that if the city attorney who's now joined us, good morning, Mr. Altum.
Morning, Your Honor.
That if the city attorney requests a fee of any type, either monetary fine or a fee relative to sentencing, if you cannot afford that, please let me know. I have the legal authority to convert nearly every fine to community service. It's my opinion that you get more than you ever give in community service, and we have a nice list of local charities that would love to have you work with them. You get to pick with whom you get to work, but I want to remind each of you, because this is very important. If you opt for community service, it's your obligation to provide proof that you've completed it. It's my policy to give people 60 days to complete that community service, but you have to provide a letter to the municipal court, and you can check in with our court clerks. They have some wonderful ways that you can avoid having to come downtown, find a parking place, and present your letter. They will show you how you can take a picture of your letter confirming completion of your obligation and email it to the court so you don't have to do anything further. Please follow up on that, though, if you choose community service. If you have any questions about anything that's going on here, I have the technical ability to remove the prosecutor and myself from the room so you can speak privately with your lawyer, Mr. McGinnis, if you need to do that. We have a lot of people here this morning. We're going to try to move as quickly as possible, and I appreciate everyone's patience. This is a rather large docket, but we have a tendency to move pretty quickly. That being said, both lawyers ready to proceed?
We are, Your Honor.
Yes, Your
All
Honor.
right, it looks like we have a visitor or two. Mr. McGinnis or Mr. Altum, could you identify the visitor? I'd like to. If it's a person who is a victim or a witness that needs to be heard, I'd like to take them first so they don't have to wait for the 64-person docket.
I'm not sure, Your Honor. We do have numerous victim cases today. Sir, with the computer or tablet labeled Luther's iPad, could you identify yourself, please?
Yes, I'm Bishop Luther Dupree, pastor of the Rehoboth Holy Temple Church of God in Christ, and I was tuning in to hear Mr. Cunningham's case.
Okay.
Thank you, Pastor Dupree. I'm very familiar with your good work, and I am the Veterans Treatment Court judge, so I will be addressing Mr. Cunningham directly. I appreciate your participation here this morning on his behalf.
Thank you, Your Honor.
All right, and because we have a visitor here, I'm going to go ahead and take Mr. Cunningham first. Mr. Cunningham, if you'd come forward, please, sir.
Good morning, Judge.
Good morning, Mr. Cunningham. As always, I'm sorry to see any of my veterans in the Veterans Treatment Court in custody. I'm hoping that you're feeling better, though.
Yes, ma'am.
All right. My question to you, Mr. Cunningham, is one of the things that I have you incarcerated for is because you were using some substances that I thought may be affecting your behavior and posing a risk to yourself. So are you feeling better?
Has the talk screen came back?
I'm not sure if it has it yet or not, but I will tell you that I have arranged for a quick mental health evaluation that should occur today. And as soon as I get the results, I will readdress your incarceration. I have been advised so that you have additional charges, so I will take that into consideration. I don't know if you've been apprised of those new charges yet or not.
Yes, ma'am. I actually had court Saturday for them, and yesterday was not the arraignment, the actual sentencing.
No, it was your arraignment. You entered a not guilty plea to both harassment and stalking.
All right. And Mr. McGinnis, could you tell me if bail has been set on those charges?
It was set yesterday in Sparks Municipal Court.
And how much is it, please?
I don't recall the amount, Judge. I just know that he entered a not guilty plea.
Honor, I see on the jail website that it's $1,000 bondable on the harassment, and the stalking does not have a bail amount.
All right. So I will advise you, Mr. Cunningham, that I have arranged for Alexa Waldman, who is one of the clinical advisors at Inner Solutions, to perform a mental health evaluation on you. No matter what happens in all these cases, I believe having some groundwork laid that we have a good mental health evaluation will direct any and all courts who are going to address your issues for a treatment program. So I'm going to ask you to be as cooperative as you can with Ms. Waldman relative to your mental health evaluation. And then if I receive that today, I will schedule you for a hearing tomorrow so we can address whatever issues you have with me at the Camo Court, okay?
Yes, ma'am.
All right, sir, I appreciate you and your patience, and I'm looking forward to getting you released from custody and into a program. And I'm working very hard with the VA relative to an appropriate program for you, okay?
Would the program be meaning I would have to be in their custody as well?
No, the program I'm considering is something called PRRC, which is a long-term program through the VA where you get to live at home.
Oh, yes, ma'am. Cool.
Okay?
Yes.
We'll keep our fingers crossed that the mental health evaluation occurs today. I never like to see my veterans locked up. And Mr. Cunningham, though you look and sound a lot better than when I initially interviewed you a couple of weeks ago, I'm hopeful that your body has relieved itself of any illegal substances that you may have ingested. So I want you to know that I'm worried about you, and I'm going to make sure that you're taken care of. I don't know if you heard, but Reverend Luther Dupree is present on your behalf from the local church. And so you have some supporters in the audience. I appreciate Reverend Dupree always for intervening on behalf of anyone in his congregation.
Thank you.
All right. And thank you, Reverend Dupree, for being here. We will keep you updated as we know more.
Thank you very much, Your Honor, and I appreciate your kindness.
All right. You take care. And I will see you, Devon, soon, hopefully, and we'll get that evaluation taken care of, okay?
Yes, Judge. Understand.
All right, ladies and gentlemen, I'm going to go back to my original list, and Reverend Dupree, you're free to sign off whenever you need to, sir. We have a special attention list that's created by the jail, and it's my obligation to address those people first. And the first one would be Todd Paluk. Mr. Paluk.
Yeah.
Good morning, sir. How do you pronounce your last name?
Pollock.
Pollock, thank you.
Yes,
Mr.
ma'am.
Pollock, your case number is 25TR09062, which tells me this is a traffic matter. I'm
Yes, ma'am.
opening up your file now. Sorry, my computer's running a little bit slow. It sounds like Mr. Altum had the same problem this morning. All right, so Mr. Pollock, you were charged on June 26, 2025, sir, with registration required, expired, or invalid registration or plates. Did you understand that charge, sir?
Yes, ma'am.
And how do you wish to plead to the charge?
Guilty.
All right, sir. You understand that by entering a plea of guilty or no contest, you're giving up your right to a trial in this matter?
Yes, ma'am.
Do you have any question about your constitutional rights, sir?
No, ma'am.
You understand that the maximum penalty for this misdemeanor could be up to 6 months in jail and or a $1,000 fine?
Yes, ma'am.
And have you served in the military, sir?
No, ma'am.
The court will accept your plea as freely, voluntarily, and knowingly entered. Were you arrested on other matters, Mr. Pollock?
Yes, ma'am.
Okay. All right. And when were you arrested?
My arrest date is says 8/11.
Okay. Well, it sounds like you've been in custody. Why don't I give you 3 days in the Washoe County Jail credit for time served, and we'll close out this case. I will ask you that you get your car registered as quickly as you can.
Yes, ma'am. Thank you so much.
All right, you're sentenced to 3 days in the Washoe County Jail with credit for time served.
All right. Thank you.
You're welcome. Michael Lopez?
While the next contestant comes up, I just want to thank Barbara for gifting yet another membership. Very much appreciated. Thanks so much.
Yes, Your Honor.
Good morning, Mr. Lopez. I feel for you. I've just got off a walker after falling down, so I know that they're a drag. Sir, your case number is 25CR12973. I'm opening up your file now. And it looks like, sir, on August 31st, 2025, you were charged with trespassing. Did you understand the charge, sir?
Correct. Yeah.
And how do you wish to plead?
Guilty.
All right. And you understand by entering a plea of guilty or no contest, you're giving up your constitutional trial rights?
I don't know.
That's a yes or no question.
Yeah.
Would you be a little bit more clear, sir?
Yes, ma'am.
Thank you. The maximum penalty for any misdemeanor could be up to 6 months in jail and or a $1,000 fine. Are you aware of that?
I am now.
Okay, does that change your mind about your entry of plea?
Yeah, let me go no contest.
Okay. You understand by entering a plea of no contest, the court, although you're not challenging, the court will find you guilty of the trespassing. Do you understand, sir?
Yes.
And have you served in the United States military?
No.
The court will accept your no contest plea as freely, voluntarily, and knowingly entered. What happened here, Mr. Lopez? Why did you get arrested on trespassing?
I mean, I was at a casino and I guess I shouldn't have been there. I was unaware that I had been priorly maybe talked to or warned about coming back.
Well, I'll tell you now, I'll share with you a secret. Now all the casinos have employed a new provision that if someone's been trespassed, they have to stay away for 3 years. So if you could have been trespassed a year ago and you would still fall within the provisions of their trespass warning. So how long have you been in custody, sir?
This is my 4th day. I believe I've been here 3 nights. And
All right. And are you currently homeless, Mr. Lopez? No. You need services, we have, and this is not just for you, Mr. Lopez, but for everybody in the audience. I want to remind you all that we have, the Reno Municipal Court has something called Community Court, which operates at the Washoe County Library located on Center and Liberty Streets. And every Wednesday morning at 9:30, they have these service providers that provide things like food stamps and housing and job placement and Medicaid, free telephones, a free bicycle, free medical attention, substance use counseling, all different kinds of things that you might need to, and they offer a free lunch. If you appear there, they can give you bus passes, all of those sorts of things. If you are financially unable to provide for yourself or you need assistance, it's free, and it's open to anyone who needs that assistance every Wednesday morning at 9:30. Do you need that assistance, Mr. Lopez?
Yeah.
I'm sorry?
Yeah, can I get that printed out on something, or, I mean, that's a lot to remember.
What we're going to do then is I'm going to refer you over to the community court, and
You know what, never mind. I don't need none of that.
Okay, well, here's what I'll do. I'm going to send you to time, Mr. Lopez, listen.
Okay.
I'm going to send you to time served, the 4 days, 3 or 4 days you've already served in custody. I'm going to order you stay away from the casino from which you were trespassed, and I'm going to invite you to go to the community court next Wednesday morning for services. Does that work?
Sounds good.
All right, that'll be my order. Tracy Martin?
Your Honor, I believe, let me check real quick. Mr. Martin, I requested a competency evaluation. I think the deputies took him back.
All right, thank you very much. It looks like Mr. Martin had a number of appearances here this morning. I'm counting one, two, three, four, at least 4 outstanding matters. 1, 2, 3, 4, 5, 6, 7 matters. So I'm going to guess, some of them are revocation hearings, so he has a suspended sentence. He or she has a suspended sentence in the court. And so we will, there will be a no bail hold on Mr. or Miss, is it a male or female?
Male.
Thank you. Mr. Martin, there will be a no bail hold on Mr. Martin pending the competency evaluation. The next matter I have on my list is Donovan Sanford. If you'd come forward, Mr. Sanford. Good morning, sir.
More.
Your case number, Mr. Sanford, is 25 CR 07648. This is listed as a case status hearing. Let me pull it up, and it looks like you entered a plea of not guilty on May 2nd, 2025 with violation of an extended protection order against domestic violence. I'm looking to see why you're in custody, but usually if you entered a plea of not guilty, you would have had a trial by now. So let's see if there's what the events indicate here. Oh, it looks like there's a warrant that was issued for your arrest on June the 3rd, 2025. I'm going to read you that warrant so you'll understand why you're in custody, sir.
Yeah, I understand why I'm here.
Let's see.
If I may just interject for a second, Mr. Alton, do you know any information on this case? That it sounds like he has a bunch of Sparks cases, and this case was potentially continued out for a global resolution, from what I can tell. And I don't know if there's been any movement on the global resolution. He said he signed a deal on his Sparks cases. He had multiple cases out of Sparks.
Yes, for everybody's information, I do see 1, 2, 3, 4, 5, 6, 7 Sparks municipal court cases, 1 Sparks Justice Court case, and 3 district court cases that he's in on. He has some high bail on the district court cases, 15,000, 15,000, 1,000. And I don't know if there's been movement on the cases. It sounds like in August, end of August, the defendant refused transport from the jail after a trial date back in late July. So our information from Mr. Loomis was that he was expecting defendant to plead to the EPO violation. That was a note in our file, July 22nd. And then there were some refusals to show up. Looks like August 28th was not a refusal. He was in district court, and I don't know what happened there.
So can you enlighten us, Mr. Sanford? What happened in the district court? Have you resolved that case or is it still pending?
Yeah, I'm just waiting for sentencing. I took a 1 to 3.
Okay, thank you. So do you want to try to resolve this now or shall we
Yeah,
wait to see?
No, that would be fine to resolve it now.
So are you prepared to tender any kind of an offer, Mr. Altum, to Mr. Sanford relative to his previous entry of plea in the district court to probably a felony?
Yeah, Your Honor, we can just offer at this point that he plead to the charge, and then we had asked to set it out for victim contact. It looks like the victim did not appear at the original trial date, but we did have a recent contact with a victim advocate from the DA's office. It sounds like the victim might be in contact with her. So if we could set this out a couple days for victim impact statement, if he does plead.
And Your Honor, if I may, this is an EPO. He'd have to fill out a waiver, and I didn't know the status of the case. We didn't go down that road yet.
All right. So, Mr. Sanford, if you want to enter a plea to this extended protection of a violation of an extended protection order, you need to go over your rights, a rights waiver with your lawyer. If I continue this to tomorrow, you want to try to do that and we'll get this matter resolved?
Yeah, that'll be fine.
So I'm sorry I didn't hear the last part of your comment.
So yeah, that'll be fine.
Okay, all right, I'll go ahead and continue your matter for entry of plea tomorrow. And we'll alert the legal defender who's going to be representing you to go over your constitutional rights and possible penalties and a waiver, okay?
All right.
So we'll continue your matter until tomorrow.
Two things while we're between contestants here. First, I'm content to ride with this judge the rest of the way if you guys are, because she's a palate cleanser. Second, I actually got an email from the fine friends at Aura who noticed that yesterday and today Ellie has been part of the ad read. It would seem they actually prefer her doing the ad read, so we may alter what we do there and just have Ellie do it. Yeah, you heard me say Aura, didn't you? And you jumped right up. Very much a supporter. What, you ready to do another ad read? Well, we're watching this judge right now, sweetheart. So we'll do one tomorrow, okay?
Were found in contempt. It looks to me like there was a warrant issued for your arrest on August the 28th. I'll read you that warrant. It probably means that you failed to comply with the court's order to take care of this insurance issue. I want to make sure that you understand why you're in custody.
I got other charges. That's why I'm here.
I'm having a hard time opening up the warrant.
It's okay. I already know what it was for.
Okay, why didn't you tell me then?
Was for not coming to court.
Okay, failing to appear?
Yes.
All right. Do you understand that failing to appear is contempt of court, for which I could sentence you up to 25 days in jail and fine you up to $500?
Yes, Your Honor.
All right, sir. Typically, all judges in the Reno Municipal Court do the same thing with insurance, because we really, all four of us, want you to have insurance, because when you carry insurance, it protects you and your family, but it also protects all of us in the community in case you're involved in an accident. Your insurance will pay for our hospitalization and property damage. Do you understand?
Yes, Your Honor.
So the standard fine for no insurance, sir, is $743 last year. Which means that, and the judges all allow you to continue the matter out and provide proof that you got insurance after the fact, which allows us to reduce the fine down to $195. Did you ever get insurance?
No, Your Honor.
Can you get insurance?
I mean,
Let's start with, do you have a car?
no.
Okay. Well, there are a couple of options that you can still take advantage of this offer to reduce the fine down to $195. You can do one of two things. You can either contact a family member, your mom, dad, grandpa, grandma, aunt, uncle, boyfriend, girlfriend, and see if they can put you on their insurance. That counts. or you can get on the computer and find out policy called an operator's policy of insurance, which usually isn't very much money. And then if you provide proof that you're insured with an operator's policy, I can reduce the fine down to $195. Would you like to take that offer?
Your Honor, just to let you know, he's been in custody since July 16th. He has a $40,000 bond and an $80,000 bond. Looks like he has an attempted murder, carrying concealed weapon, and battery with the use of a deadly weapon.
Thank you, Mr. McGinnis. That makes it easier. Why don't we do this then to resolve the issue? And it sounds to me like you're not going to go anywhere for a while, Mr. Santiago. Why don't I convert the $700 fine to 7 days in the Washoe County Jail, and we'll call it good.
Yes, Your Honor.
All right, but please keep in mind, I want you to get insurance when you get out of jail and get all these things resolved, okay?
Okay.
All right, your matter's resolved with time served. Gail White? Miss White's case number is 25 CR 12980. Good morning, Miss White.
Good morning, ma'am.
Miss White, you are charged in that matter I've just referenced with the crime of domestic battery first offense arising from September 1st, 2025. Did you understand the charge?
Yes.
And is it your intention this morning to enter a plea of not guilty and schedule it for trial?
Not guilty. It was self-defense.
Okay, all right, just thank you. That's a yes or no question. So I'll go ahead and accept your not guilty plea. Don't say anything more because we're being recorded. You could jeopardize the facts of your case, okay?
Okay, ma'am.
All right, so I'll accept your not guilty plea. Can you afford your own lawyer, Miss White?
No, I only get $1,084 a month from Social
Okay.
Security.
All right, so I will appoint a legal defender to represent you. I will order that you make contact with that legal defender prior to the trial date. I'm going to give you that trial date and the legal defender's name right now, and then it'll be your obligation to make contact with your lawyer prior to the trial date. Do you understand?
Yes, ma'am.
All right, may I have a trial date, please, for Miss White?
Yes, Judge, and just so for your information, she currently does have another case for domestic battery scheduled for September 16th at 1 p.m. with Keith Loomis, and it is the same victim. I don't know if you want to consolidate it or
So, Mr.
keep it
Alton,
separate.
thank you, Ms. Gonzalez. Mr. Alton, what's your pleasure here? Are you interested in consolidating the two matters for judicial?
Economy.
Thank you.
Yeah, I think that'd be wise, Your Honor. It is the same victim. Miss White has no prior criminal history, but now has picked up, looks like, 2 domestic battery first offenses in the last less than a month, so last couple of weeks with the same victim, her husband. So yeah, we'd ask for bail to be set in this case. I don't know if she has bail on the other case, and then if we could consolidate these to the same date, that would be great.
Any objection to that course of action, Mr. McGinnis?
I think consolidating is appropriate. Thank you.
Thank you. So, Ms. White, you know what we're talking about? Basically, we're going to put the two cases together so you don't have to come to court multiple times. Do you have any objection to that?
No, ma'am. Not at
All right.
all.
What's the city's position relative to bail?
Again, Your Honor, same victim, Claire White, her husband. It kind of, there's no independent witnesses in this case. There was an argument going on. She claimed that the reported victim, her husband, threw a knife at her, took her phone, spit in her face. The evidence showed that the defendant had scratched the reported victim, Claire White, in the face and grabbed his beard. He had some scratches on him. And so the evidence leaned toward Miss White committing the domestic battery. 2 cases now with no prior criminal history. So with this new case with one already pending, the city's going to ask for a $3,000 bondable bail, no contact with Claire White, CLAIR White. And that's it. 8200 Offenhauser Drive, number 109F.
E. Sir, E, 109 E is in Edward.
All right, well, thank you, Ms. White. Mr. McGinnis, do you wish to be heard? It looks like, as I'm looking through the file, looks like bail was set by the reviewing court at $5,000. So we'll reduce that down to the $3,000 bondable that's been requested by the city attorney. Do you wish to add anything, Mr. McGinnis?
I know that my client doesn't want to stay in custody till the 16th for her pre-trial. She has lived in this community for over 44 years. She has no criminal history other than the most recent domestic battery where she was cited, from what I can tell. She has been living in the same address for 21 years. She's on disability, Social Security disability. She says that she can live with her, I believe it's her son and not the named victim. I'll submit it based on that, Judge.
Thank you. Ms. White, is it true that you have another place to live other than with the alleged victim in this matter?
Yes, ma'am. Yes, ma'am. As long as I get my medicines and my belongings, yeah.
Okay, well, you know that you can do that by contacting the non-emergency line for the Reno Police Department. You'll get some police officer to stand by while you get your personal belongings and your medicine. You understand how that works?
That works beautifully. Thank you, ma'am.
All right, I'm going to reduce your bail down to $1,000 with the following conditions. That you obey all laws, you have no alcohol or drugs without a prescription, including marijuana, and you have no contact with the alleged victim, Claire White, that you make all your court appearances. You will be, now, if you haven't had contact with Mr. Loomis, you need to get on it and talk to him very quickly about the facts of your case. So do you understand those are the conditions that you're required to obey?
Yes, ma'am. I sure am. Thank you, ma'am.
You're welcome. That will be my order.
Okay, thank you, ma'am. I have one question, ma'am.
Yes.
Do I ever get to go home and live in my own place?
Well, right now you're under the court's jurisdiction, so you need to follow the rules. There'll be some resolution one way or the other on the 16th.
Oh, okay.
Okay?
Right. Yes, thank
Okay.
you, ma'am.
You're welcome. Do we have a try? Oh, yes, we do. 9/16. Thank you. Jaden Wood.
I know. It's easy.
Morning, ma'am.
Good morning, Mr. Wood. I have two matters for you this morning. The first is, it looks like a revocation hearing, which means you have a pending underlying sentence in 25 CR 07371. I'm going to go over that with you now. It looks like on May 28th, 2025, sir, you were found guilty of simple battery. It was originally filed as a domestic. It was reduced to a simple battery wherein you entered a plea of guilty and were found guilty of that charge. I'm looking to see what the underlying sentence was relative to that simple battery. Can someone enlighten me relative to the underlying sentence, please?
I have 120 days, Judge.
All right.
Yeah.
So the question I need to ask you, Mr. Wood, is you understand that you have 120 days in the Washoe County Jail suspended for a period of either 1 or 2 years on the condition that you don't break any other laws. That's one of the first conditions of any suspended sentence. Do you understand if you're found guilty or enter a plea of no contest to any new charge, you could be subject to revocation of that prior underlying sentence?
I do, Your Honor.
All right, very good. Let's go over the new charges then. And they are 25 CR 12494. And that's another domestic battery from August the 23rd, 2025. Did you understand that charge, sir?
I do, Your Honor.
All right. So, and is it your intention to enter a plea of not guilty and schedule the matter for trial?
Yes, Your Honor.
The court will accept your not guilty plea. We'll schedule the matter for trial. Can you afford your own counsel, sir?
I cannot, Your Honor.
I'll appoint a legal defender to represent you. May have a trial date with a legal defender, please.
And Judge, this is for Mr. Wood, right?
Yes, Jaden Wood.
I'm getting that for you now.
Thank you.
We have October 14th at 8 a.m. with Keith Loomis.
All right, Mr. Wood, your trial date is October the 14th. The time is 8 a.m. Your lawyer is Mr. Keith Loomis. I will order you make contact with Mr. Loomis prior to the trial date so the two of you can be prepared. You've got a lot riding on this, so a couple of things you need to know. I'm looking to see if bail has been set. Looks like a no bail hold, so it looks like you refuse to be transported to the court. Does the city wish to be heard as to bail?
Yes, Your Honor. We're going to be asking for a $10,000 bail. It's the same victim as the other simple battery case. We were able to prove the case that he has a suspended sentence in with an independent witness. So he pled to the simple battery in that prior case. This case looks similar. He is 12 on his risk assessment, high with pending cases. He also has a Nebraska pending case, it looks like. According to his risk assessment, misdemeanor conviction, violent crime, failures to appear, and then getting to his criminal history, it's 15 pages. Has battery in 2024 that was eventually dismissed. Failures to appear, numerous, as indicated, previous domestic, just kind of all manner of criminal history, at least in Nevada. Getting to Nebraska, he has some criminal history there as well. Based on his risk assessment, 10,000 with a pending suspended sentence is appropriate. But also ask for no contact with Michaela Edwards.
Thank you. Mr. McGinnis, do you wish to be heard?
Thank you. I think the city's met its burden for a monetary bill. The issue would be how much. I think regardless of how much the court sets, this individual is not going to be able to post a bond. I did look at the holding bill, and it was at $4,000 at some point in time for the holding bill. Would ask that you keep that the same.
Thank you. Mr. Wood, were you employed at the time of your arrest?
I'm currently self-employed, ma'am.
And what do you do for a living?
I do construction.
All right. And do you have a place to live other than with the victim?
I do, Your Honor.
Okay. Well, I'm very concerned about the 15-page criminal history and the 12, which is very high on your risk assessment. Based upon everything I've heard, I'm going to set your bail at $7,500. That's bondable with the following conditions: that you obey all laws, you have no alcohol or drugs without a valid prescription, including marijuana, and you have no contact with the victim, Miss Michaela Edwards. Do you understand those conditions?
Yes, Your Honor.
That'll be my order.
Judge, what's the bail amount on the suspended sentence case? Currently on a no bail hold as well.
All right, we'll go ahead and set that at $2,500. That will be consecutive to the bail in this matter. That's bondable.
Thank you, Judge.
Thank you for reminding me. All right, the next matter that we have before us is Audrey Biggs.
Your Honor, she's next door to Sparks Justice. If we could.
We'll see her later. Danielle Garing. Yes. Come on up, Miss Garing. Good morning.
Good morning.
Miss Garing, your case number is 25 CR 12860. I'm opening up your file now. It looks like you were charged on August the 30th, 2025 with the crime of simple battery. Do you understand the charge?
Yes.
And how do you wish to plead to that charge?
I'm not guilty.
All right, the court will accept your not guilty plea. We'll schedule the matter for trial. Can you afford your own counsel?
No.
What do you do for a living?
Nothing. I'm homeless.
Okay. And you're not working, correct? How do you support yourself?
I just live on the street.
All right, I will go ahead and appoint a legal defender to represent you. We'll set the matter for trial. May I have a trial date, please?
Yes, Judge, I have October 14th at 8 a.m. with Keith Loomis.
All right, so Ms. Garin, your trial date is October the 14th. The time is 8 a.m. and your lawyer is Mr. Keith Loomis. I will order that you make contact with Mr. Loomis within about a week to 10 days. That's when he'll get the paperwork for your case, so the two of you can go over the facts and circumstances of your matter to prepare a defense. Do you understand?
Okay.
All right, and city's position as to bail in this matter? It looks like bail was previously set on September the 1st at $750 bondable.
And Your Honor, was that at a hearing?
You know, September the 1st would have been, yes, it would have been.
Oh yeah, I do see that. I'm sorry. Yeah, so there's already been a bail hearing.
Okay. Mr. McGinnis, do you want to be heard in any way?
You'll submit it, Judge.
All right. So, Ms. Guerin, your bail has been set at $750 bondable. If you are able to post bail, the conditions for your release will be as follows: that you obey all laws, you have no alcohol or drugs without a valid prescription, including marijuana, and that you have no contact with the alleged victim in this matter, whose name is Mr. Alton.
It's Nalita Talley. It's her aunt.
Okay. I see that here. It's Nelita Do you understand you have no contact with that person, Ms. Guerin?
Okay.
All right, so that'll be my order. Your bail has been set.
Okay. Thank you.
Okay, friends, a couple of minutes early, but this is the logical place to leave it with my camera out of focus. Come back to me, camera. Oh, well, look at me out of focus. That's okay. I hope you all had fun today. I did. Some heavy stuff. Not as heavy as we've seen in the past, though. And this judge that we finished with here, I really like her. I wish she would stream more. I hadn't, we saw her like 2 weeks ago, and I hadn't seen her since. But now she was back today. So I think when we see her, I'll try to pull her up and we can watch a little bit. Anyways, we'll be back tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, a half an hour early for channel members. Tomorrow is also sidebar, so that will be fun too. And Ellie, you want to say bye? Tell them goodbye? Or just walk away? Not sure. All right, so again, we'll be back tomorrow, 10 a.m. Eastern, 7 a.m. Pacific, as my camera finally comes back into focus. Y'all have yourselves a great Wednesday. Take care. God bless.